Quickly list item number 1.
And the petitioner is the informant. Her younger sister has been kidnapped by the opposite partner 5, who is a married person, and not recovered till now. And the victim is a minor girl, 15 years.
Who is that boy?
Opposite partner 5,
No, it's all right. Is the same village or
pura different village,
you have implicated him as opposite party number 5, and he's a married person? Yes, Mr.
I will take instruction. I will take instruction, my lord.
This writ petition in the nature of WPCRL in the habeas corpus has been filed with a prayer for direction to the opposite parties number 1 to 4 to search the minor daughter of the petitioner, who is stated to be aged about 15 years, and to produce her before this court. The learned counsel for the petitioner submits that opposite party number 5, S.K.SAHOO, who is a married person, has kidnapped the what is the relationship between this petitioner and that girl, daughter?
Prohibited relation.
No. About this petitioner and that victim.
Victim, sister, petitioner is the elder sister.
Elder sister of the petitioner is the elder sister of the victim. And she lost the first information report before Inspector in charge of Purana Bajar Police Station, Bhadra, on 14/11/2023 against the opposite party number 5, on the basis of which Purana Bajar PS case number 349 of 2023 was registered under section 363 of the Indian Penal Code. And even though in the meantime almost 3 months have passed, but almost 3 months have passed, but the investigating agency has not taken any sincere step for rescue of the minor sister of the petitioner. So also to arrest the opposite party number 5. Learned counsel for the state, who has received the copy of the writ petition, seeks some time to obtain instruction particularly the steps taken by the investigating agency for rescue of the victim girl and to arrest the accused, and steps taken to rescue the victim girl. You'll produce the up-to-date case diary on the next date, which is fixed to week commencing from 26th February 2024. Copy of the order be handed over to the land council for this day. Yes.
Obliged.
Item number 2.
May I please listen? Tell us the The wife and minor son of the petitioner has been kidnapped by one Vishwaketu Pradhan, and now there is a threat perception.
Hmm.
The wife and minor son of the petitioner has been kidnapped, Lordship. In this regard, the petitioner brought it to the knowledge of the Inspector
No,
in
by
charge,
whom?
Lordship.
By whom?
By one Vishwaketu Pradhan, Lordship.
Why have you not made him a party? So
Lordship.
also your wife. And what is the material to show that you are married and you are the father of that child?
Lordship.
Any documentary
But
evidence?
next one, I brought it to the knowledge of the
No,
IIC Council.
you have
Lordship,
filed
Lordship.
just a complaint, the complaint which has been made. So where is the documentary proof that you have married to one? You mentioned that Rama Rupana or something like.
Lordship.
And this Sambhu Manda is your son, aged about 7 years.
Lordship, 7 years. Lordship.
So hard that person a party and
Lordship, may permit to implement the accused Vishwaketu Pradhan.
have you got any documentary evidence when the marriage took place?
Lordship, I was in Bhubaneswar to.
You're asking a question
Lordship,
when your
Lordship.
marriage took place with that Rama.
That
And
is
when
not.
that boy Sambhu Mandal was born, where is the birth certificate to show that you are the father of that child?
In the complaint itself, Lordship, the petitioner,
Uh-huh.
when he was outside the home and he returned to the home, came to know that, Lordship.
We want to know that what is your status?
Lordship.
What is your right to say that somebody has kidnapped your wife and minor child, as you said, but you are not producing any document to that effect that she is your wife and this boy is your child, and not only that, you have not implicated that person as a opposite party because
Lordship.
they are necessary parties. Tomorrow, you may come and say that your so-called wife may come and say that I am voluntarily staying and I have not married this petitioner. It's a false statement he is making.
Lordship, I am permitted to implement the accused as OP4,
Yeah.
and on the next day, I will produce such document with regard to the establishment of the marriage and the.
This writ petition in nature of habeas corpus has been filed with a prayer for a direction to the opposite party number 1, 2, 3 to search for the wife and minor son of the petitioner from the illegal custody oblique detention of one Tanagona.
One Lordship, Vishwaketu Pradhan, Lordship.
Court lecture
Annexure 1 body ଅଛି ଘରେ କେହି ନଥିବାର ସୁଯୋଗ ନେଇ ଆସାମୀ ବିଶ୍ୱକେତୁ ପ୍ରଧାନ ପିତା
petition is concerned in which paragraph you have stated? Para 1. One Vishwaketu Pradhan. Since the said Vishwaketu Pradhan has not been arrayed as a party, the Land Council for the petitioner seeks permission to implead Vishwaketu Pradhan as opposite party number 4. Permission is granted. Subpara. When a query is made to the Land Council for the petitioner as to what is the documentary proof to show that the two persons named in the writ petition are the wife and minor son of the petitioner, is it some time to produce the documentary evidence? Next week?
Absolutely.
Okay. Put up this matter next week. Give him the both the writ petition so that he will make necessary correction. And also in the state's copy also you make it correct. It is to be implemented in permission. You put your cert signature and
Lordship,
date,
Lordship.
and it is to be countersigned by
Lordship,
you.
in OP3, Lordship, wrongly typed as Marine R police station, RB deleted, Lordship. OP3, Inspector in charge, Marine, R Tamajiri police station.
Okay, in the opposite party number 3, the police station, in the police station name, one R has been added, and the land and counsel for the petitioner is permitted to score out the same. Okay. Yes.
Okay.
Item number 3.
The petitioner. Wait. Let me see that order. Okay, on 16/4/21, when we granted interim bail, there was a direction that the inspector in charge of Lalbagh police station shall keep a close watch on the conduct of the petitioner during the interim bail period and submit a report in that respect to the Land and Council for the state so as to reach this court, so and so. So that report you are supposed to furnish. Yes. This is the report. Granted interim bail. So paragraph 5, Mr. Das, it indicates that he was taken into custody on 7/10/2005. And when we granted him interim bail in 2021, by that time he had already remained in custody for more than 15 years and 6 months. So now the paper book is ready. Hold the paper book. No, it's not ready. There is nothing. Two paper books, right? Okay, we are directing for, you have received the paper book? We are directing it to be added to the paper hearing list. We are granting bail to him also for interim bail. Right. As for the order dated, no, the previous order, this one. As for the order dated 16/4/2021, it upon लिखिए IA number 686 of 2022. Oblique दे दियो तो IA number so and so for interim detail. As per the order dated 16/4/2021, passed in IA number 125 of 2020, the Land Council for the state has produced. Report dated 7/2/2024 of the IIC Lalbagh Police Station, Cuttack, UPD, wherein it is mentioned that during the interim bail period of 3 months granted by this court, the petitioner was regularly appearing before him, and neither he was involved in any case nor any complaint has been made against him during the said period. The report is taken on record. Since the paper book is ready and it's an appeal of the year 2010, and the learned counsel for both the parties have received the paper book list, the matter be added to the hearing list in the week commencing from 26th February 2024. Since the petitioner has not flouted the terms and condition of the interim bail order, and is in judicial custody for more than 18 years by now, we are inclined to release him on interim bail for a period of 3 months. From the date of release, Baki paragraph 10, 11, 12, 13, 14, एगुड़ा सब समान रखिदेवे हेलो एटा नहीं published of the earlier order है ना से जो 16/4/2021.
Item number 4.
Lordship, I prefer a password.
490. Is this matter along with further Arata connected matter to accused? And another matter is Shepherd 258. Yes. Yes, item number 4.
Yeah, Lordship, I prefer a password. Lordship, I prefer a password.
Tomorrow.
Obliged.
Yes.
Obliged.
Item number 5.
May I please be Lordship? The appellant,
But in this case, deposition copy is not yet selected.
You are moving bail on merit.
My lord.
Earlier never rejected.
No.
So supplying.
It was listed before Honorable Justice D. Das and Honorable Justice G. Satpathy. As my Lord Justice G. Satpathy was the trial judge then.
Okay.
In this case, that's how it has been listed
now,
before.
It has to be heard by this bench. So
Yes.
Supply the deposition.
Yes,
copy.
yes. In course of the day, I will supply.
So we can take up this matter day after tomorrow or
Day after
Monday, my lord, Monday.
next.
Monday.
Day after tomorrow is holiday.
Oh, I see. Right. The learned counsel for the state submitted that he has not received the deposition copies. Let the learned counsel for the appellant supply the deposition copies to the learned counsel for the state by tomorrow. Put up this matter in the week commencing from 19th February 2024. Mr. Mishra, have you filed Vinama?
My lord, my associate power is there.
Yes.
Item number 6.
Praise the Lord. Last page, Lordship direct to file my lord, the appear before the court below. As per instruction, the petition has appeared, and this one court directed to meet with the children at Saranpur,
Just a minute. In pursuance of the order dated so and so, the petitioner and the opposite party are present. Petitioner makes a grievance before this court that in spite of the order dated so and so, when she contacted IAC of Bolgod police station over phone to meet her children, who are in the custody of their father, opposite party note for the IAC Bolgod misbehaved with her, which she has recorded. And she may file an affidavit said effect giving copy to the land council for the state enabling taken action. Petition submit that she has not been given opportunity to meet her children. The opposite party note 4 submit the distance between each place of abode and the place of abode of the petitioner is around 160 kilometers, and he has no objection to producing any particular date, and in spite of the order recent, the petitioner is facing problem getting no assistance and so on so forth to bring the children to so on so on so on. Necessary arrangements shall be made by the ISO in the morning to avoid any kind of hindrance preventing the company for few hours so that and to that reports shall be furnished with the ISO and children who come today they shall be allowed to remain in the company of the petitions. Will not be any hindrance from meeting us with for the land council in future meeting. And the next date of CM is going to come. So what is this CMA 29 of 2020?
Is that has been restoration filed by the opposite party husband regarding taking the guardianship. That was dismissed for non-prosecution.
He filed that petition.
Yeah.
That was dismissed for
Non-prosecution.
non-prosecution.
Then he has filed a CMA.
CMA.
You lordship directed to appear on that.
You have already appeared.
You appear.
Now you said that the date is posted to 8th February 2024.
And
So what happened?
In advance, the present petitioner appeared on 27/1/2020.
Yes. Now what is the stage now?
8224, she was ill, that's unable to come to the court at the reckoning. But she has appeared in that case.
No.
Next,
Whether the CMA application was disposed of or it is still pending?
that instruction I have not
No,
got.
both of you are for the petitioner.
I am for the opposite
Party now. So what happened on that day? You both of you said that it was fixed to 8th February 2024. That has already passed. That was on Thursday. So what happened on that day?
Regarding that, I have no instruction. For me to take instruction.
Because the relief which she is claiming that can be best adjudicated by the concerned court, family court, and if an application has also been filed, a petition been filed, but that was dismissed, be that as it may. So that CM and dispose it upon earliest. That restoration ହେଇଗଲା ପରେ ଛାଡ଼ିଦେଲେ ତ ସେଇଟା ହଉଛି problem. So by the way, any improvement in the meantime?
Your lordship directed, she has went to my lord Ladu Baba.
On that day, Ladu Baba.
Yes, my lord. That the report of IIC. The report I will receive. Let it tomorrow. I will submit.
No, what happened on that day?
Yes, she met with the.
Ask her to come. ସେ ପିଲାମାନଙ୍କୁ ଡାକନ୍ତୁ ଛାଡ଼ନ୍ତୁ ପିଲାକୁ ଛାଡ଼ନ୍ତୁ ଏପଟୁ ଆସି ତାଙ୍କୁ ମାଙ୍କ ପାଖକୁ ସେପଟେ ଯାଆନ୍ତୁ ମ୍ୟାଡାମ ସେ ମାଇକ୍ କୁ ଯାଆନ୍ତୁ ନାଇଁ ପିଲାକୁ ଡାକିବେ କମ୍ ତାଙ୍କୁ ନେଇକିନା ଆସନ୍ତୁ ଆପଣ ବି ଆସନ୍ତୁ ଆରେ ହଁ ନେଇ ଆସନ୍ତୁ ଠିକ ଅଛି ଆପଣ ସେଦିନ ଯାଇଥିଲେ ସେଇ ଯୋଉ ପିଲାଙ୍କ ସାଙ୍ଗରେ ଦେଖା ହେଲା ତ ଆଚ୍ଛା ଆପଣଙ୍କର ଯୋଉ appear କରିଗଲେଣି ସେ ଯୋଉ ଫ୍ୟାମିଲି କୋର୍ଟରେ ଯୋଉଠି କେସ୍
ଯାଇକି କରିଛି ସାର୍ କରିଛି ଯାଇକି
ସୁବିଲେନି
ଯାଇକି କରିଛି
appear କରିଛନ୍ତି ଯେ ସେ କେସ୍ ଉପରେ ବର୍ତ୍ତମାନ ନିର୍ଭର କରୁଛି ଯେ ତାକୁ ବିଚାର କରିକିନି ये करिवे पिला माने कहा पाखे रहिबे वर्तमान तो आमे आपन को सुजोग दउछु पिलांग सहित मिसिबा पई आउ किंतु अल्टीमेटली से कोर्ट ही डिसाइड करिवो हला तेणु से केसटा जो फाइल करथिला आपन को स्वामी सेटा डिसमिस हो जाइछि ताकू पुणी आउ थरे चलेया पई से गोटे दरखास्त देइचंदी जार सुनानी पई थिला 8 फेब्रुआरी 8 तारिख दिन थिला आ केबे अछि बाबू माने कहि परनांदी से बुझिकिन कहिबे
8 तारिख दिन कोन हला जानिछथि
सब देह खराब थिला जाइना
posted to 8/4/2024
84
माइलो
एडवांस करिकिन ताऊ डील करिया हम कहि दोछि हमें कहि दोछि
माइलो
2024 लॉन्ग
8
डेट
फेब्रुआरी 8 एप्रिल को नै जाइछथि ताको
से ताको एडवांस करिने मु कहि दोछि हम कहि दो सो दैट इट कैन डिस्पोज द
8 तारिख दिन कोन हला जाइथिले कोर्ट को कोन हला
प्रेजेंट पकी सारा से
प्रेजेंट पकी आसिले आपण स्त्री उपस्थित थिले किबा तांको वकील गले निसे दिन नोटिस पाइछो ता धरे
ଯାଇଥିଲି ସାର୍ ବୋଲେ ମୋର ଦେହ ଖରାପ ଲାଗି ମୁଁ କହିଥିଲି ଯେ ଆପଣ ଏଇ କରିବେ ମୁଁ 8 ତାରିଖରେ ଯିବି
8 तारिख रे जीवो बोली
ଆଜ୍ଞା ଦେହ ଖରାପ ଥିଲା
आपणकर जो दरखास्त दिया है आपण हाजिर हो सारे जदि से केस रो किछि आपणकर आपत्ति नाही बेली लेखिकिन जदि देई देबे आपण वकील को परामर्श करी ताले तांको केसटा पुणी रेकॉर्ड को फेरी आसीबो मेरिट रे जहा डिसाइड हबो आ जदि आपण आपत्ति दियंती ऑब्जेक्शन दियंती ताले ता ऊपर गोटे सुनानी हेकिनी कोर्ट ऑर्डर पास करिवो से केसटा को पुणी आनिबे कि केसटा मूलरू खारज करदेबे जहा भी हबो सेठी ये हबो तेणु आपण को वकील परामर्श करी जहा करबा कथा करंतु किंतु जेतु कोर्ट गोटे लंबा तारीख दउचंती तेणु ताकू कहूचु आमे जे ताकू एडवांस करिकिनी आपण को कम्युनिकेशन करदेले आपण माने तादरे सहयोग करंतु सो दैट केसटा अर्ली डिस्पोज ऑफ हे जिवो आउ वर्तमान आज आछंती आपनको पिला मानक सहित समय कटांतु बाकी जेते बळे आपण चाहिए आईआईसी को जनइले छुट्टी दिन देखिकिनी पिला मान कारण से माने पढ़ुचंती हाँ एवं से 160 किलोमीटर दूरतार रहउचंती जदि सियाकू ये करी तम कहबे सेमती कहबेनी जे प्रत्येक सप्ताह आनिकिनी मते पहुंचांतु तेणु आपण बोलगोड थाना आईआईसी से भीतर बंदोबस्त करिवे जेबे
ଶରଣକୂଳ ଥାନାଟେ ଦେଖିଥିଲେ
हम
ଶରଣକୂଳ ଥାନାଠି
ओडी शरणकुल
ଶରଣକୂଳଟେ
बोलगड़ थाना लास्ट से
शरणकुल थाना दरकार होला ठीक है
आईसी शरणकुल को हम डायरेक्शन देते
ସାର୍ ସେଇଟା ଆପଣ ତାରିଖ ପକେଇଦେବେ ନା କେତେ ତାରିଖରେ ସେ ଦେଖା କରିବେ ମାନୁନାହାନ୍ତି କୋଉଥିରେ କି ବି
तांकर मन करंतु आम गोटे तारीख पी करू पिला मानक देह कार कौन थिबो से तांकर कौन असुविधा थिबो तेणु आपण जो तारीख कहिबे सी बुझिबे तांकर किछि सुविधा असुविधा सेन नथिले बा पिला मानक स्कूल थिबो विभिन्न कारण ही पारे तो आगु
मोटरसाइकिल गैरेज रे काम करछन ना
ଶୁଣିବେନି ଆପଣ କହିଦେବେ ତ ମୁଁ ଏଠି ଯିବି ମାନିକି ଫୋନ ବି କରିବି ତ ଆଙ୍କେ ଶୁଣିବେନି ଏବେ ବି ଲୋକ ନେଇକି ବି ବାଡିଆ ମାରା କରୁଛନ୍ତି ଜେଲ ମାନେ ଥାନାକୁ ବି ଯାଇଥିଲେ
ଥିଲେ ନା କରୁଛନ୍ତି
ବାଡିଆ ବାଡି ବି କରୁଛନ୍ତି ଥାନାକୁ ବି ଯାଇଥିଲେ ମାନେ ମୋ ସାଙ୍ଗରେ ବାପାଙ୍କୁ ଯିଏ ସପୋର୍ଟ କରିବେ ତ ତାଙ୍କ ନାଁରେ କେସ୍ କରିକି ବହୁତ ପଇସା ପତ୍ର ମୋର ଖର୍ଚ୍ଚ କରଉଛନ୍ତି ତ ଆମର ଏତେ ପଇସା ପତ୍ର ନାହିଁ
just 10 days back
why that IIC has not submitted the report
for Uncle Miller
yes
Miller later tomorrow I will get it
no these they it can be taken up tomorrow but their presence will not be there we are directing again list it tomorrow but lekhondu in pursuance of the order dated 8/1/2024 the petitioner the opposite party number 4 and their 2 children are present. The land and counsel for both the parties are also present. it is during interaction, the petitioner stated that as per the order dated 8/1/2024, she got the opportunity to meet her children in Lodubaba Temple at Saranpur on 28th January 2024. And IAC Saranpur Police Station also cooperated. It is further told to us by the Land Counsel for both the parties that the petitioner has already entered appearance before the who court is a case pending before the Learned Judge Family Court Khurda in CMA number 29 of 2023 on 8th February 2024, and now the case is posted to 8/4/2024. CMA number 29 of 2023 has been filed for restoration of what is that number original
98 of 2020.
CP number 98
Yes,
of
2022.
2022, which has been filed by the opposite party number 4 for the custody of the children.
Right.
For the custody of the children. The Learned Counsel for both the parties submit that in view of the urgency in the matter, the Learned Judge Family Court Khurda be directed to advance the date and to take up CMA number 29 of 2023 with due intimation to the parties. Okay. In view of submission made by the Land Counsel for the respective parties, CMA number 29 of 2023, which is stated to be fixed on 8/4/2024, is to be advanced by the Learned Judge Family Court Khurda. तो को तारिख रे अपियर करिवे कोन आपण दी जन जाक एई मासरे कोन हम 8 तारिख करी छाड़ दउ
15 days, lordship, 15 days time.
15 days माने कोन 26th रे हले चलेबो
26
हां 26 तारिख रे आज से हला 26 February 2024. None of the parties shall seek for an adjournment and cooperate with the Learned Family Court for disposal of the CMA number 29 of 2023 in accordance with law. The Learned Judge Family Court shall do well to pronounce the order in CMA, final order for them, CMA number 29 of 2023 by 2nd of March 2024. Objection, if any, to CMA number 29 of 2023 be filed by the petitioner either on 26th of February 2024 or prior to that, serving copy in advance to the Learned Counsel for the opposite party number 4. Since the children have come today, they shall be allowed to remain in the company of the petitioner till 4 o'clock. And there should not be any hindrance in the meeting of the petitioner with their children. both the land and council shall ensure that meeting of the petitioner with her children is made in a cordial atmosphere in concert.
ସେ ଯୋଉ ହାଇକୋର୍ଟ ଲାଷ୍ଟ ପେଜ
Praise. Okay. हाँ ସେଟା ବୁଝିକିନି ସେଟା ଲେଖିଦେବେ ସେଟା କଣ ତ କହୁଛନ୍ତି ହଁ ଠିକ ୱାର୍ଡିଂ ଦେବେ ହଁ
Last time the order was there.
Last order.
and registry shall make necessary arrangement in that respect in providing a room in so and so for meeting of the petitioner with the two children.
ଗତ ଥର ଯୋଉ କୋର୍ଟ କୁ ଆସିଥିଲେ ଛୁଆମାନଙ୍କ ସାଙ୍ଗରେ ଦିନ 4ଟା ପର୍ଯ୍ୟନ୍ତ ରହିଲେ
ଆଜ୍ଞା ସାର୍
ଆଜି ବି ଆପଣଙ୍କୁ ହେଲା ଆପଣ ଛୁଆଙ୍କ ସାଙ୍ଗେ ସମୟ କଟେଇବେ ଆପଣଙ୍କର ଉଭୟ ପକ୍ଷ ଆପଣଙ୍କର ସ୍ୱାମୀ ଆଉ ଇଏ ତ ସବୁ ଅଛନ୍ତି କିନ୍ତୁ ଅସୁବିଧା ହବନି ବାକି ଲେଖନ୍ତୁ ସେ ଯୋଉଟା ଓକେ
8/4 ଯୋଉ ଡେଟ୍ ସେ ଡେଟ୍ ନୁହେଁ ଆମେ ସେଟାକୁ 26/2 କୁ ଫିକ୍ସ କଲୁ ଉଭୟ ପକ୍ଷ ସେଠି ହାଜର ହେବେ 26/2 ରେ ଆପଣଙ୍କ ତାଙ୍କ ଯୋଉ ଆପ୍ଲିକେସନ ଦେଇଛନ୍ତି ଯାହା ଦବାବ ଦବା କଥା ସେଇ ଦିନ ବା ତା ପୂର୍ବରୁ ଦେବେ ସେ 2/3 ସୁଦ୍ଧା ସେଇ କେସ୍ ଟାକୁ ଡିସ୍ପୋଜ ଅଫ୍ କରିବେ ଅର୍ଡର କରିବେ
2 ତାରିଖ ସୁଦ୍ଧା 2 ତାରିଖ ସୁଦ୍ଧା
ହେଲା
ଆଉ ଲେଖି ଦିଅନ୍ତୁ since the IIC Saranpur police station has not furnished the report as per the order dated 8/1/2024 and the land council for the state submits that the report will be furnished during course of this week. We direct the opposite party number 4 to bring the children to bring the children to କୋଉଠି ଆପଣ ଦେଖା କରିବାକୁ ଚାହୁଁଛନ୍ତି ପିଲାମାନେ ସେଇ ଲଡୁ ବାବା ଟେମ୍ପଲ ରେ ତ ରାଇଟ୍ ଲଡୁ ବାବା ଟେମ୍ପଲ at Saranpur on ଏଇଟା ତ 26 ତାରିଖ ଦିନ ହବ ଆପଣ ତାଙ୍କୁ 25 ତାରିଖ ଦିନ ନେଇ ଆସନ୍ତୁ ତାଙ୍କୁ ସେଦିନ ଟାଇମ ସ୍ପେଣ୍ଡ କରିବେ ସେଠି ରହିଯିବେ ତାପରେ 26 ତାରିଖ ଦିନ କୋର୍ଟ କାମ ସାରି ଏକାଥରେ ଯିବେ on 25th of February 2024 at 10 a.m. necessary arrangements shall be made by the IIC Saranpur police station in the morning to avoid any kind of hindrance to the petitioner to remain in the company of her children for few hours and to that effect a report shall be furnished by the IIC Saranpur police station to this court through the Land and State Council on the next date of listing which is fixed to ଆପଣଙ୍କର 2 ତାରିଖ ଭିତରେ ହେଲେ ଆପଣ ଜାଣି ନେବେ ରେଜଲ୍ଟ ଟା କଣ ହେଲା so let it come on 11th of March 2024 put up this matter on 11th of March 2024 free copy of the order be handed over to the ଯାହା ଅର୍ଡର ପାସ୍ ହେଲା ତାଙ୍କୁ ବୁଝେଇ ଦିଅନ୍ତୁ ବର୍ତ୍ତମାନ ତାଙ୍କୁ ନେଇକିନି ଏଠି ସେ ଆରେଞ୍ଜମେଣ୍ଟ କରିକିନି ରେଜିଷ୍ଟ୍ରି ଆରେଞ୍ଜମେଣ୍ଟ କରିବ ରେଜିଷ୍ଟ୍ରିଙ୍କୁ ଖବର ଦେଇ ଦିଅନ୍ତୁ ହେଲା ଯାଅ It will come on 11th March 2024 and your IIC to submit the report and also make necessary arrangements so that they can
free copy ma'am
yes free copy.
Item number 7.
Item 7 minutes. एटा गोटे काम करो एटा टिके टाइप कर दियो है ना तो पठेई दियो इंस्ट्रक्शन पठेई दियो एटा कि रजिस्टर जुडिशियल बुझियो ना कि बुझियो हां रजिस्टर जुडिशियल खबर दे दियो इमीडिएटली ताको जो रूम को नहीं जिवे तुम यस
May visual lordship.
just a minute. Yes, you are supposed to produce a report regarding the conduct of the petitioner in jail from the concerned jail superintendent. As per the order dated 5th of February 2020.
Last report. Kindly pause a minute. Received the report. Can I took tomorrow, my lord?
Yes.
What is your response
My
to the
lord.
submission made by the State
Lord,
Council
my lord,
on
yourselves kind,
February 2024?
Lord, kind permission. The judgments, Lord, which take
No,
the
no,
head
so
is
far as
not
the
resolution.
dated 26 September
My lord.
2000, clause 4 of the said resolution.
You are found guilty on 17/7/2004.
My lord.
So as on the date of conviction, that resolution was in force. That guideline, which was issued by the NHRC, and that was the state has adopted. So that was in force. So obviously,
Yes, my lord.
some kind of restriction has been there.
My lord. 2000 guidelines, as your lordship is rightly saying that quorum meeting and the my lord eligibility criteria doesn't my lord suit or any uh, relaxation is not. Docket with model. And also thereafter 2005 also that is no liberal aspect as per Supreme Court.
Whichever is more liberal,
So-
that is to be taken into account.
So far, my lord,
But
these two
everything where it is mentioned about that prisoners convicted for offense of so and so and murder of public servant. It's a case of murder of public servant.
yes, my lord.
So that is why the it specifically indicate about ineligibility of for premature release. But subsequently, it has been liberalized in the sense that only after 25 years of that is recently, I think 2022 guideline has been issued. Mr.
Super.
Das,
My lord.
is that the correct?
My lord, 2000 जो guideline टा हला, that is implied to because conviction is 2004, my lord.
हाँ.
So at that time there is a restriction that there should not be religion.
Totally restricted.
Totally.
That was liberalized in
In 2022.
22, and but that says about
25 after
25.
25.
But his grievance is that one of the Co-accused.
And that was he was released prior to the 2022 guideline.
Okay.
No, how? On what basis?
That is the report, my lord. He was released
He has some adverse report there.
because there was no adverse report against that petition.
That's why we had called for report
That's
regarding his conduct.
recently, my lord.
So it can be taken up day after.
Day after tomorrow छुट्टी है ना?
Kali,
Kali tal.
If it can come tomorrow, you
yes,
can.
sir, because it is already there.
It's all right. Mr. Mishra will take up this matter tomorrow. All right. এটা কিছু করিয়া দরকার নেই, খালি কালি ডাকিবে হ্যালো। So 13 to 20. Yes.
Well, I will take two judgments as your lordship is that the conduct. Supreme Court has rated judgment. That guideline I have not taken ground. I will read to lordships only two aspects about the SP's mechanical application of mind.
No,
that
you are
is
claiming parity.
parity, my lord, and conduct as well as the
report
authority. So in this peculiar similar concern, the Honorable Delhi High Court, keeping note of Supreme Court judgments, remanded back to the state advisory board.
No, obviously, if we are satisfied, the only thing is that it is to be sent to the sentence. So that is one part. But thing is that let that report
comes, my lord.
Because already something is against you, and number two about that relaxation has come during 2022. So that can be applied to you also, but provided that there is some
yes, to your lordships too.
Yes, rider in that.
I got the report.
No, give a copy. We'll
Yes,
take up this matter tomorrow. Just
yes,
pass
yes,
in or
yes.
to him. For that. Okay.
Grateful, my lord.
Yes.
Item number 8.
Your lordship has already had it in part, but to refresh your lordship's memory, paper just a minute. ଗୋଟେ written note ଦେଇଥିଲେ ସେ। Mr. Mahanti, the other day you are mainly attacking the evidence of the two eyewitnesses, PW4 and PW5, in view of the finding of the PM report.
Doctor.
That rigor mortis is one of the factor which shows that if the postmortem has been conducted as per the eyewitness account within 22 hours or something like, but the PM doctor's evidence is that the death must have taken place prior to 30 hours. So that shows the time in which the eyewitnesses stated that the occurrence has taken place. Perhaps the occurrence has not taken place at that time. That was,
which my intention is that it must not have taken place at 1:30.
Right. So it must have been taken place. The death must have been prior to that.
5:30.
And if that be so, the witness could not have been, who were present at 1:30 at that place, could not have got the opportunity to see the occurrence. But again, we pointed out to you that how this determination of the age of date of time of death, only basing on the rigor mortis aspect, it will vary from so many factors it depends upon. But he has just indicated only one aspect about the rigor mortis, and on that ground question we pose to you that when the doctor has not taken into account the other aspects which are also relevant for determining the time of death from the so and in view of the Modi's jurisprudence, that cannot be the sole determinative factor. Can we reject the evidence of two eyewitnesses whose evidence has almost remained unchallenged? That is the.
In fact, to answer your lordship's query, my lord, I have all these aspects, my lord, which your lordship is posing me regarding those climatic condition and condition of rigor mortis, etc. And your lordship is correct that doctor has nowhere explained this. But Honorable Apex Court, my lord, which on case of Dinesh Kumar versus State of Haryana, I have given in page 12 of my note that it depends on the prosecution and the court itself.
कौन है दिनेश कुमार?
At page 14, your lordship, page 12. And in page 14, the third paragraph, I may be permitted to read out.
In that case, there was a case of eyewitnesses.
No, circumstantial. Circumstantial. That is circumstantial.
That is the problem, is that when you compare two cases, you must see there was no eyewitness in that case. Here there are eyewitnesses. So we have to discard the evidence of the eyewitnesses only on the expert's opinion, which is not conclusive in nature. He has not. Before we accept the expert's opinion, the law is that the reasons have to be given by the expert. When the reasons is faulty, because it does not correlate to this Modi's jurisprudence, then if the reasons are faulty, can we, on the basis of expert's evidence, we'll just discard the evidence of the two eyewitnesses. So that may be a case that it's based on circumstantial evidence. Some observation might have come. That's a different matter.
So that is a case of my lord, circumstantial evidence.
Yes.
And in another case, my lord.
So here also, this PW 4 and 5, they have not stated they have seen the appellant starting the disease.
They have
seen that he was running away with that.
They had and rushed to the spot. While reaching there, my lord, they found out that
he is
my lord, that aspect is there. Just to, my lord, address that aspect only, it's a doubt in my mind.
What are the materials on record to disbelieve the statement of PW 4 and 5?
I'm coming to that. Your lordship if your lordship will scan both the entire evidences of PW 4 and PW 5, my lord, they have nowhere stated, my lord, that they took a shortcut to reach the spot. Nowhere they state.
अरे सेमाने कहले आमे पहुंचिलु
मिलो
आपण आनिबे ना जे आपण एपटे एमती गोटे रास्ता अछि सेपटे आउ किछि बाट नाही
yes, it is there, Miller. In evidence of other witnesses that the distance to reach there is no shortcut.
They were not
they will say they said that we reached the. It is you to show that they followed that path. Otherwise, they would not have reached within short time. And by the time, if they would have taken that particular path, reached at the spot, the appellant after committing the crime would not have been there.
Which your lordship is asking, that is not admittedly not in PW4 and PW5's evidence. It is not there.
ତେଣୁ ଗୋଟିଏ ମନେ କରନ୍ତୁ ଗୋଟେ ଘଟଣା ସେଇ ବାରଣ୍ଡାର ସେପଟେ ହେଲା ତ ସିଏ କହୁଛି ଆମେ ଗଲା ବେଳକୁ ଦେଖିଲା ବେଳକୁ ଡେଡ୍ ବଡିଟା ପଡିଛି ତା ଦେହରେ ଷ୍ଟାଫ୍ ଇଞ୍ଜୁରି ଅଛି ସିଏ ପଳେଇ ଯାଉଛି ଆପଣ କହିବେ ଆଜ୍ଞା ସେ ଜାଗା କହିଲେ ଏମିତି ବୁଲିବ ସେମିତି ଯାଇକିନି ଏମିତି ବୁଲିକିନି ତାପରେ ସେଠିକି ଆସିବ ଏପଟେ ଯଦି ସିଏ ଯାଇଥିବ ଆପଣ କହିଦିଅନ୍ତି ସିଏ କହିନି ଯେ କେମିତି ପହଞ୍ଚିଲା ଆପଣ ତ ଆଣିବା କଥା ସେ ଏପଟେ ବୁଲି ବୁଲି ଗଲା ଏ ଡିଷ୍ଟାନ୍ସ ଟା ହଉଛି ଏତିକି ଜଣେ ପହଞ୍ଚିବାକୁ ଦୌଡି ଦୌଡି ଗଲେ ବି ଏତେ ସମୟ ଲାଗିବ ତେଣୁ it is not possible on his part to see the appellant's presence at the scene of occurrence.
In fact, my lord, PW14 and PW9 categorically says that there is no shortcut available to reach the spot.
This is not a question of shortcut to reach the spot or not.
Challenging their presence itself.
The question is that whether you have brought anything that they have not seen the accused at the spot. There is nothing.
ଏଇଟା ହଉଛି ଗୋଟେ ତଳେ ନାଳ ଯାଇଛି ସେ ନାଳ ପାଖରେ ଡେଡ୍ ବଡି ପଡିଛି ଆକ୍ୟୁଜ କୁ ଦେଖିଲେ ନାଳ ପାଖରୁ ଦୌଡିକି ଯାଉଛି ହାତରେ ଅଛି ୱେପନ ତ ଏଇ ପୋଜିସନରେ ଆସିଲେ ଯଦି ଉପରୁ ସିଧା ଖସି ଆସିବେ ସେଠି ଇମିଡିଏଟଲି ଆପଣ ପହଞ୍ଚିଯିବେ ତେଣୁ ଆପଣ ଗୋଟେ ବାଟ କହୁଛେ ନର୍ମାଲ ରୁଟ୍ ଟା obviously ଗୋଟେ ଭଲ ବାଟଟା ଅଛି ସେଠିକି ଯିବା ପାଇଁ ଆଉ ଗୋଟେ ବାଟ, କିନ୍ତୁ ସେମାନେ କୋଉ ପଟେ ଗଲେ ସେଟା ଆପଣ ପଚାରିବେ ନା ସିଏ କାହିଁ ପଚାରିବେ?
ଆମେ ତ ପଚାରୁନୁ PW4 ଆଉ PW5 କୁ ସେ ବାବଦରେ କ୍ୱେଶ୍ଚିନ୍
ନା।
ପଚାରିବୁ, there is no such question, but question was specifically asked to IU
ହଁ
and PW9
ହଁ
whether any shortcut available to reach that spot or not.
ବିଲ ଭିତରେ ଡେଇଁକି ଯିବାକୁ ମନା ନାହିଁ, ଉପରେ ଠିଆ
They are saying, my lord, they are deposing after reaching the spot. I could see that he is running away with a knife in his hand.
କାରଣ ହାଇପୋଥେସିସ୍ ରେ ଗୋଟେ କୋର୍ଟର ଇଏର ଏଭିଡେନ୍ସ କୁ ଡିସକାର୍ଡ କରିବା ଆଣ୍ଡ ଯେତେବେଳେ ଜଣେ ଲୋକକୁ ଷ୍ଟାବିଂ ହେଇଥିବ ନର୍ମାଲ ଇଏ ହେଇଛି ସେ ପାଟି କରିଛି ଜୋରରେ ପାଟି କରିଥିବ ମାରିଦେଲା ଯୋଉଟା କି ଏମାନେ ମଧ୍ୟ କହୁଛନ୍ତି, ସୋ ଇମିଡିଏଟଲି ଆଟେନସନ ଡ୍ର ହବ। ସୋ ସେମାନେ ଉପରେ ଅଛନ୍ତି ତଳେ ହଉଛି ଇଏଟା, ସୋ ଦେଖିଥିବେ, ଦେଖିଲେ ପସିବିଲିଟି ଅଛି ଇଏ ଦୌଡ଼ିକି ଦେଖିଯିବ, କାରଣ ଆଉ ସେଠି କିଛି ଏମିତି ଜାଗା ନୁହେଁ ଯେ ଯୋଉଠି ନ ଦେଖି ହବ। ତେଣୁ ଫାଙ୍କା ଜାଗା, ଜଣେ ତା ସ୍ୱାମୀ ଦୌଡ଼ିକି ଯାଉଛି, ସ୍ତ୍ରୀ ପଡ଼ିଛି, ଏମାନେ ତେଣୁ ଆପଣ ଯୋଉ କ୍ୱେଶ୍ଚିନ୍ ଟା ପଚାରିଛନ୍ତି ଆଇଓ କୁ ବା ଗୋଟେ ପର୍ଟିକୁଲାର ୱିଟନେସ୍ କୁ, ସିଏ କହୁଛନ୍ତି ଯେ ନର୍ମାଲ ରୁଟ୍ ଟା ଆଉ ଗୋଟେ ବାଟ ଦେଇକି ଯୋଉଠିକି ପହଞ୍ଚିବାକୁ ଟିକେ ସମୟ ଲାଗିବ। ସେ କେତେ ସମୟ କହୁଛନ୍ତି?
1 kilometer.
ହଁ 1 kilometer।
More than 1.5 kilometers.
ହଁ କିନ୍ତୁ
Page
ଏଠୁ
52.
ଆମେ ଯୋଉ ସ୍ପଟ ମ୍ୟାପ ରେ ଦେଖୁଥିଲୁ ସେଦିନ,
ଆଜ୍ଞା,
ତ ଏଠୁ ଯଦି ଡାଇରେକ୍ଟ ଇଏ ଖସି ଆସିବ ସେଠୁ ଦେଖିଦବ ନା।
ଯୋଉ ଚାରିକୋଣଟେ ଗୋଟେ ଅଛି ସ୍ପଟଟେ ଯୋଉଠି ନାଳର ଆରମ୍ଭ ହଉଛି,
ହୁଁ
ଜଣେ ସେଠୁ ଠିଆ ହେଇକି ବି ଦେଖିପାରିବ,
ହଁ ଉପରଟାରେ ଆଉ ତଳେ ଏଇଟା
ଦେଖିପାରିବ।
and their presence, my lord, is also questioned by the evidence of PW13.
and motive behind the commission of crime, that just 2 days back or something like that, he has submitted a report because the appellant was assaulting him, and the matter was to be referred to the punch. But before that, this occurrence has taken place. Is it correct?
Yes,
Yes,
yes.
my lord. On Saturday, occurrence took place. Meeting was supposed to be held on Monday.
Right.
2 days thereafter.
Just before the date of occurrence,
Right.
he submitted the report.
Now, if you come to this PW4 and PW5,
Page 50.
this PW4 has also stated that at that time, page 50, at that time, I along with Rebati Patra means
PW5.
PW5. And Minati Patra is?
Not examined.
Okay, not examined. Weeding out the grass from the cultivable land of one Sribocha Patra, right?
Again.
Sribocha Patra has not been examined.
No.
Okay. The Malarbasa Pala is at a, say jo jagata is at Nala, in Nala, is at a distance of 100 feet from the place where we are working. Okay. Having the hearing the cry of the deceased Morigali Bua, we rushed to the spot and found that the deceased was lying dead on the spot with profuse bleeding injury on the right side belly, and also found the accused was running away from the spot being armed with knife. So the accused fled away towards the jungle. Then we raised the alarm, villagers came. ये जो लास्ट लाइन टा देखंतु पेज 51 रे paragraph 4 our land is at a higher level than the nala and we were weeding out the grass having bent down. Our lands are surrounded by the ridge. Then suggestion was given. She has denied that it's not a fact. I have not seen the occurrence. The nala is visible to our query. Again, brought out in the cross-examination clearly. We have to go to the nala through the land of Sadapatra. We three simultaneously came running to the spot. The said nala is not being used by the villagers or the same situated at a distant place. Nobody was present at the spot at the time of our arrival. It was a rainy season. At the relevant time, it was not raining. I have not seen the assault on the deceased by the accused. The dead body was lying. Acha, eta jo statement, it's not a fact that I have not stated the IO. That eta se kohichi. Eta মানে ভুলে তাও পচরাইছি এটা in fact there is no such contract.
has already verified.
We have verified. The dead body was lying on the land through which the rainwater was passing through. Now it's not a fact that I have not stated the value was lying on the floor. It's not a fact that I have not stated we raised alarm thereafter so and so. এটা ସବୁ କହିଛି
ସବୁ କହିছে।
This is Subhadra is my co-villager. I along with the husband have been staying in my parents' house since our date of marriage in order to look up. So এই जो क्रॉस एग्जामिनेशन ने जहाँ आपण बाहर करिसेंती डिस्टेंस टा होची जमा 100 फीट नंबर 1 गोटिए बिलो क्रॉस करिकिनी गले से जगह रे पहुंची जीवो से बिलोटा होची सदापात्र
जोटा हमें मैप रे अछि जोटा
हां मैप
श्रीवत्स पत्र एटा ना सदापात्र होची
शिवच पत्र ता तळगु नळाटा
श्रीवत्स
तापरे PW5 मध्य
सेम
सीए भी कहूची जे मु PW4 सहित थिली मिनती पात्र नॉट एग्जामिन तो almost identical that हमें देखिलु ये dead she was lying dead with bleeding injury at that time found the appellant running away towards the jungle holding knife এটা মধ্য corroborate କରୁଛି PW4 ସହିତ there was profuse bleeding on her so and so
इवन जदि किछि टाइम भी लागिछि पहुंचे तांकु से जगह रे सेठी PW5 रो से आउरी भी कहूछि जे हमें पहुंचला को शिवछ दौड़ी के नाला जस्ट क्रॉस कर साणी तन जति टाइम ताको हल्ला रे सुनी के आसी जंदी पहुंच दो से ऑलरेडी सेठी वाटा क्रॉस कर साणी
no thing is that they could have said that हमें आसी देखिलु ताको भूसी दा
exactly
that is what
So-
Leonard Sessions was also
हाँ
what he also said.
the fact that the whatever they have seen they are different
दे
ତେଣୁ ଆଚ୍ଛା ପାଖରେ ଆପଣ କହିବେ ସେ ତ ଖାଲି ଦୌଡ଼ି ପଳଉଥିଲା ତାକୁ ତ ଆକ୍ଚୁଆଲ ଦେଖିନି there was no other person ହେଲା he was the only person who was there and keeping in back that background the
holding the knife also.
holding the knife ଆପଣ ଯୋଉଟା ଆଣିଲେ 1 କିଲୋମିଟର ସେଟା କୋଉ ବାଟ ଦେଇକି ଗଲେ 1 କିଲୋମିଟର?
ସେଟା PW9 କହୁଛି।
ସେଟା କୋଉ ବାଟ ଦେଇ ଗଲେ 1 କିଲୋମିଟର? 100 ଫୁଟ ଦୂରରେ ଆଉ 1 କିଲୋମିଟର କଣ ସେ କୋଉ ପଟେ ସେ?
There is no direct path from Nala to agricultural field.
ସେଟା ଫିଲ୍ଡ ରାସ୍ତା ଦେଇକି
ନା ନା କୋଉଠି ସେ କଣ?
Page 68 मिलो, paragraph 3.
ଇଏ ଯେମିତି ଜଣେ କହିବ ଚାନ୍ଦିନୀ ଚୌକ ମନ୍ଦିର ହଉଛି ଏଠୁ ହଉଛି 100 ଇଏରେ, ଆଉ ଜଣେ କହିବ ନାଇଁ ସେ ଏଠୁ ସେପଟକୁ ଯିବ ତାପରେ ବକ୍ସି ବଜାର ଆସିବ, ବକ୍ସି ବଜାର ଯିବ ସେ କଟକ ଚଣ୍ଡୀ, ଚଣ୍ଡୀ ଛକରୁ ଏମିତି ବୁଲିକିନା ଆସିଲେ 4 କିଲୋମିଟର ଲାଗିବ। ସେଇଭଳିଆ
The land is higher in level than the canal and Bordjora Nala.
150
Bordjora
feet.
Nala and the canal are not visible from the agricultural land. The width of Nala is about 7 feet. There is no direct pathway from Nala to agricultural field.
Same is the evidence of IO.
ସ୍ପଟ୍ ମ୍ୟାପରୁ କ୍ଲିୟର ଜଣା ପଡୁଛି ଏଇଟା ହାୟର ଲେଭେଲରେ ଅଛି। ସେଇଟା ଗୋଟେ ଏପଟେ ସେ ବର୍ଷା ଦିନରେ ଏଇଠି ପାଣି ଆସି ସିଏ ଠିକ ଅଛି ଆଉ ଏଇ ଏଠୁ ଏଇଟା ଦେଖା ହଉଛି ଏଇପଟେ ସେମାନେ ଆସିଛନ୍ତି ଆଉ କଣ 100 ଫିଟ୍ ଖଣ୍ଡେ ଆସିଛି। ସିଏ ଗୋଟେ କୋଉ ଡିଷ୍ଟାନ୍ସ କଣ ଗୋଟେ ପାଣି
ନାଇଁ ସେଇ କଥା ବି IO କହୁଛି।
You
lordship me kind.
Land is higher in level than the canal and the Bordjora Nala. Bordjora Nala and the canal are not visible from the agricultural land.
ନାଇଁ ସବୁ ଜାଗାରୁ obviously ଦେଖାଯିବନି। ଆପଣ ଯଦି ଏପଟ ସାଇଡରେ ରହିବେ ତାହେଲେ ଏଇଟା କୋଉଠି ଦେଖାଯିବ? ବେଶୀ ଉଚ୍ଚା ନାହିଁ। where you are there, if you come to this ଏଇ ଯୋଉ ପାଖକୁ ଚାଲି ଆସିଲେ you can see that place। ତେଣୁ ବଟ୍ ଯଦି ଏ ସାଇଡ କୁ ରହିଯିବେ ତ ବିଲଟା ଅଛି ତଳେ ଅଛି ନାଳ, ତ ଏଇପଟେ ଯୋଉମାନେ ଥିବେ ଉଚ୍ଚରେ they can see it, ବଟ୍ ଯୋଉମାନେ ସେପଟ ସାଇଡ କୁ ଇଏ କରୁଥିବେ they might not see। ତେଣୁ କୋଉଠି ଏଗୁଡାକ ସବୁ କ୍ରସ୍ ଏକ୍ସାମିନେସନ, କାରଣ ସେମାନେ କହୁଛନ୍ତି ଆମେ ଇଏ କଲୁ କ୍ରସ୍ ଏକ୍ସାମିନେସନରେ କିଛି ନ ଆଣିକିନି
ତାଙ୍କୁ ନ ଆଣିକି ଅଲଗା ୱିଟନେସ୍
ତାଙ୍କୁ ନ ଆଣିକିନି ଅନ୍ୟ ସାକ୍ଷୀଠୁ ଗୋଟେ ନେଇ ଆସିକି
ସେମାନେ କୋଉ ପଟେ ଗଲେ କଣ କଲେ ତାକୁ ଆଣିନାହାନ୍ତି।
ସିଏ କୋଉ ପୋଜିସନରେ ଥିଲେ ସେମାନେ କହୁଛନ୍ତି ଆମେ ଦେଖିଲୁ, ଇଏ ସାକ୍ଷୀ ସେଠି ଟୋଟାଲ ନଥିଲା, ସିଏ କହୁଛି ଦେଖାଯିବନି।
କୋଉ ପଟେ ଗଲେ କଣ କଲେ ତାକୁ କିଛି ନାହିଁ। କୋଉ ପଟେ ସେମାନେ ଗଲେ nobody
Actually, what your lordships has observed, that they could have said that we have seen the assault. They didn't say that. Exactly on that point, my lord, Learned Sessions has convicted.
No, that is it indicates that one could have said so. IO ର କୋଉ ଏଭିଡେନ୍ସ ଅଛି କଣ?
86 page 86 first paragraph.
ସେ ଯୋଉ 1 କିଲୋମିଟର ଯୋଉ କହୁଛି
ସେ 80 କିଲୋମିଟର କହୁନି, but କହୁଛି there is no passage to stream from the land of Srivastava.
ସବୁବେଳେ କାହିଁକି ଜମି ଗୁଡାକରେ ରାସ୍ତା ଗୋଟେ ଥାଏ, କିନ୍ତୁ ଜମିକୁ ଡେଇଁକି ଲୋକ ବି କଣ କରି ଯାଆନ୍ତି। ଯେତେବେଳେ ହାଲା ଯେତେବେଳେ
first paragraph
21
third line, second line from the top.
There is no passage to the stream from the land of Srivastava. One has to come to the Nala through the field.
ନାଇଁ ଡିଷ୍ଟାନ୍ସ ଟା କିଛି କହିନି
ନା ଡିଷ୍ଟାନ୍ସ କହିନି।
One has to come to the Nala through the field. ସେ ଚାଷ ଜମି ଭିତର ଦେଇକି ଆସିବ।
ଆଉ ସେଇ ବିଲ ଗୁଡାକରେ ରାସ୍ତା କୋଉଠି ଆସିବ ସେଠି?
ଜେନେରାଲ ରାସ୍ତା ଜଣେ ଯାଉଛନ୍ତି, ଜଣେ ସେ ରାସ୍ତା ଖୋଜିବ, ବଟ୍ ଯେତେ ଗୋଟେ ଅକରେନ୍ସ ହଉଛି ଜଣେ ଶୁଣୁଛନ୍ତି what happened, they will not find the way to where they will go.
ସେ ହୁଡା ଉପରେ ନର୍ମାଲି
ଉପରେ ଡେଇଁକି ପଳେଇବେ।
ଆଉ ସେ ଯୋଉ ରିପୋର୍ଟ ଟା ଦେଇଥିଲା ମାନେ ଇଏ ସେ ବିଷୟରେ DC जो report ଦେଇଥିଲା against the appellant ରେ
ଆଜ୍ଞା
ସେ
ସେଟା ବି
ବିଷୟରେ ହଁ
ସେଟା ସ୍ପେସିଫିକ କରୁଛି
that has also been exhibited.
yes exhibit that has proved and also the leading to discovery the weapon was recovered from the jungle on the instant of the present accused murder and that was also and that was also identified by the doctor and also the witness seizure witness.
My argument was that no blood stain was found and
Because there was a running
sealed condition.
It was a rainy season and it was recovered after so many days. କେତେ ଦିନ ପରେ
5 ଦିନ ପରେ 5 days ପରେ
ଗୋଟେ ପଥର ଉପରେ ଥୁଆହେଲେ
ଆଜ୍ଞା ଜଙ୍ଗଲରେ ଗୋଟେ
and what the doctor has also seen about the nature of injury caused. The doctor is PW
8. Page 63.
The first one is a stab wound of size 5 cm, 2 cm, 7 cm on the right side abdomen, grievous in nature.
oblique in direction.
Oblique in direction. এটা upward ଯାଇଛି ବୋଲି କହୁଛି ବୋଧେ ତାପରେ. Incised wound ହଉଛି so it's a simple in nature. Internal examination, a stab wound was directed obliquely upward on penetrated right side liver. Muscles and peritoneum below the wound was cut. Abdomen was filled with clotted blood. Margins of wound showed gaping. Liver was pale. Penetrated spleen and kidney were pale. Heart contracted and chambers empty. Right lung and left lung were pale. Presence of bleeding and gaping of margin of wounds indicate that both the wounds were antemortem in nature. Cause of death is due to hemorrhage shock resulting from stab wound. Time since death is more than 36 hours as rigor mortis has passed on. The injury can be caused by knife produced before me. Injury number 1, that is the stab wound, can cause death of the person in ordinary course of nature. He examined that MO1, which was shown to him. He correctly identified and so on. से जो आम से दिन देखी से मोदी जूरिस्प्रुडेंस पढ़ागला से बहीटा मोटा बहीटे थिला नहीं से गुड़ा में हाँ एटा नहीं से पेजटा बाहर कर दियंतु जोटा से दिन बाहर कर देइथिले
That's 51. 451.
नहीं से नंबर नथिला तो से देखियो
Your Lordship was reading this book.
एटा अन्य केस रे हेयर कैमोसिस सरला
एटा my lord has marked.
According to the doctor, in the month of December, in a place like Swansea, the rigor mortis may set after about 2 to 3 hours after the death. He stated that for the rigor mortis to reach in the leg to head, it would take 12 hours, and the same would remain in existence for about 12 hours. Thereafter, it would gradually diminish in the reverse direction, that is from head to leg, for about 12 hours. And on this basis, when he examined the body of the deceased, he found the rigor mortis at reverse almost to the end of legs. By this process, he came to the conclusion that death in question must have occurred 39 hours before this monster. So the prosecution has re-examined the doctor on other points. Question was put to him in regard to that part of the evidence report. It was held that since there is no cross-examination on this point, and there will be no other material to prove that the evidence of the doctor is either not scientific contrary to science purpose. It was if this doubt regarding the time of the prosecution case. There is a particular case ro ye kari kouch.
ଆଜ୍ଞା
It's not that nai tankro we found on that day that rigor mortis cannot be the sole factor for determining
Lordship
that.
was searching to
Searching for the
Google.
Google my lord was
Acha, acha.
Lordship was searching
on
to
that day.
Google.
ଆଉ ଗୋଟେ ସେ ଯୋଉ କହୁଛନ୍ତି 1 kilometer my lord to cover 1 kilometer you will go through the evidence of that
वीरेंद्र वर्सेस स्टेट ऑफ यूपी टा किए प्लेस करथिले आपण प्लेस करथिले ठीक है वीरेंद्र वर्सेस स्टेट
No,
ऑफ
no.
यूपी अच्छा एटा ଗୋଟେ कोन से नथि
Your lordship was verifying one judgment, that is Hanga Velu versus State of Tamil Nadu, 2002 SCC Milord.
एसेडा बही गुडा कटी मगेटे 2002
2002 6 SCC.
2002 तो
Again,
वॉल्यूम 6
6 SCC page 498
498
Milord.
कौन पार्टी ना
Thanga Velu, THANGAVELU versus State of Tamil Nadu.
VALU
Again,
वर्सेस स्टेट ऑफ तमिलनाडु
that is what your lordship was verifying.
एक बार कर दिया होगा एटी असली है ये अच्छी की तो এটা খুব ক্লোজ করো সে এসসিসি টা বার করো বার করো এটা স্কুইজ করে দিও এসসিসি টা বার করো हाँ एससीसी साइटेशन दिया फाइंड बाय साइटेशन जड़े पड़े एटी हाँ से क्लिक करो अरे रिटर्न
କାରଣ ଗୋଟଟା
देखेगा फाइटा कौन एससीसी राइट फर्स्ट এটা বার করো 2008 है देन 16 एससीसी होची 582 अरे मगेई दियो है हाँ ଆଉ ଗୋଟେ ମଗେଇଲ ସେ ଯୋଉ କହୁଛନ୍ତି 2002 ଭଲ୍ୟୁମ କ୍ଲିକ୍ କର ଗେଟ୍ ଦି ସାଇଟେସନ ମାର୍କ ହଉଛି ବୀରେନ୍ଦ୍ର ବର୍ସେସ୍ ଦେଖିବା medical jurisprudence rigor mortis aid in determining the time of death ଦେଖା ହଉଛି ଏଇଟା ଟିକେ କମେଇ ଦେଲେ ଦେଖ ଆଉ ଟିକେ ଉଠେଇଦବା ଟିକେ କମେଇ ଦେଲ ଟିକେ ନଇଁ ଦେଲେ ହଁ ଦେଖା ଅଛି ଦେଖା ହଁ In general, rigor mortis sets in 1 to 2 hours after death is well developed from head to foot in about 12 hours, is maintained for about 12 hours, and passes of in about 12 hours. Riger, in the instant case, rigor mortis was present in lower extremities at the time of autopsy was conducted on the dead body after 30 hours. According to the ocular testimony, the deceased was murdered on 5th Swanso at Dostagore, and the doctor conducted the autopsy on the dead body on the next day, that is for Chatta Tiris. That is after 36 hours. But the rigor mortis was found present in lower extremities. Had he died on Swanso at about 10 a.m. also, rigor mortis would have passed up from the dead body completely at the time of autopsy. Thus, the ocular testimony that he was murdered on Swanso at about Swanso stands corroborated from the medical evidence. Pinpointing that rigor mortis was present in lower extremities at the time of Swanso. ବାହାରରେ ସେ କହୁଛନ୍ତି ଇଏ ଆରମ୍ଭ ହବ 2 ଘଣ୍ଟାରେ ଷ୍ଟିଫନେସଟା ସେଟା ବାହାରରେ ପୁରା ରିଚ୍ କରିଯିବ ବାହାରେ ତାପରେ ଏଠି 1 to 2 is well developed Swanso. It is maintained ସେଟା ରହିଲା ପରେ ତାପରେ ଆଉ 12 ଘଣ୍ଟା ସେଠି ରହିବ ହେଲା then ଧୀରେ ଧୀରେ ସେଟା reduce କରିବ 24 hours 24 hours ପର୍ଯ୍ୟନ୍ତ ରହିବ ମାନେ 12 ଘଣ୍ଟାରେ ପୁରା reach କରିଯିବ then ଆଉ 12 ଘଣ୍ଟା ସେଟା ରହିବ then it starts to 24 ଘଣ୍ଟା ପରେ ସେଟା pass up କରିବ ହେଲା pass up କରିବ ପୁଣି ସେଟା ଧୀରେ pass କରିବ maintain for about 12 hours ହଁ ସେ maintain and passes up in about 12 hours ହଁ ତାମାନେ ଆଉ 12 ଘଣ୍ଟା ଲାଗିବ ଆଉ 12 ଘଣ୍ଟା ଧୀରେ ପାସ୍ କରିଯିବ ତାମାନେ 36 hours ପରେ ଆଉ ଟୋଟାଲ ନଥିବ ସିଏ ସେଇଥିପାଇଁ ନାଇଁ ନା ଏଇଟା ଆଉଥରେ in general ପ୍ରଥମେ 1 to 2 ଘଣ୍ଟା ଭିତରେ ଆରମ୍ଭ ହବ ମୁଣ୍ଡରୁ ତଳ ଆଡକୁ ଯିବ ଫୁଟ ଆଡକୁ in about 12 hours ହେଇଗଲା ତାପରେ ମେଣ୍ଟେନ କରିବ ଆଉ 12 ଘଣ୍ଟାରେ ଠିକ ଅଛି passes of in about 12 ମାନେ ଟୋଟାଲ ପାସ୍ କରିଯିବ 12 hours ତେଣୁ ସେ ଧୀରେ ପାସ୍ କରିବ ତେଣୁ lower extremities ରେ ତମେ what it means to say that 36 hours ହେଇଗଲେ after 30 hours according to the oral also the deceased was and the doctor conducted on the dead body on the next day in 38 hours of the dead body. The rigor mortis was found present in the lower extremities. ତାମାନେ ସେ ଯୋଉ 36 ଘଣ୍ଟା ପାସ୍ କରୁନଥିଲା ତ ସେ lower extremities ରେ ଥିଲା ତେଣୁ ସେଥିପାଇଁ ସେ କହୁଛନ୍ତି since the death is more than 36 hours and rigor mortis fast ଏଇଟା ଦେଖିବାକୁ ପଡିବ କିନ୍ତୁ 36 ଘଣ୍ଟା ଯାଇନି his submission is in this case the doctor has stated that the time since death is more than 36 hours as formula অনুযায়ী কই দিয়েছি his submission is it was done before expiry of 36 hours right then so obviously say you should but that is that हाँ नहीं से formula अनुଯାयी देखिले ସେ formula ଅନୁଯାୟୀ ତା statement ର ଇଏ ଠିକ ଅଛି କିନ୍ତୁ ଏଇ ଯୋଉ formula ଟା that cannot be the sole determinative factor ସେଇ ଯୋଉଟା decision ଅଛି eye witnesses ସେଟାକୁ ତମେ ଇଏ କରିପାରିବନି ସେଇ ground ରେ ତମେ discard କରିପାରିବନି ଏଠି ମଧ୍ୟ କହିଥିଲେ ସେଟା ଦେଖିବା ସେ ଖୁବ କରାଯାଏ ଏଠି ମଧ୍ୟ ଇଏ କରୁଛନ୍ତି ଏଠି ଅବଶ୍ୟ ଟ୍ୟାଲି କରିଯାଉଛି ତେଣୁ ଆଇ ୱିଟନେସ୍ କୁ ଆକ୍ସେପ୍ଟ କରିକିନି ସେ rigor mortis ର ପୋଜିସନ କୁ ନେଇକିନି ଆକ୍ସେପ୍ଟ କରି କନଭିକ୍ସନ କରିଛନ୍ତି
that part was not discussed that part was not discussed in the judgment rigor mortis passing off has not been discussed nor it was raised there
ଗୋଟେ ସେମାନେ honorable Supreme Court quote କରିଛନ୍ତି ଏଇଟା ହଉଛି Modi's jurisprudence 77 edition page ହଉଛି 125 ହଁ ସେଟା କଣ subsequently କେମିତି ଉଡେଇ ଦେଲେ ସେଟା important ଇଏଟା ଏଇ ଯୋଉ ବହିଟାରେ ନୂଆ ବହିଟାରେ ଦେଖିଲା ବେଳକୁ କିଛି ନାହିଁ ତାକୁ ଟିକେ କହିବେ ଯେ ମୋଦିଙ୍କର ମେଡିକାଲ ଜୁରିସ୍ପ୍ରୁଡେନ୍ସ 1977 ର ଥିବ ଇଏରେ ହେଲା ସେଇଟାକୁ ଆଣିବେ नेक्स्ट डिसीजन बाहर कले ये जो 2002 कौन कौन बैक करिए
Actually, that judgment was 2002 para 5
चलो सही है हाँ क्लिक कर 2002 अरे साइड उन्होंने मझे कौन भी कर हाँ ସେଇଠୁ ଆରମ୍ଭ କର 2002 ଭଲ୍ୟୁମ 6 then 498 अरे तो देखा जाऊंगी there is are you facing some problem okay 498 good citation it order so according to the doctor in the month of December in a place like Europe the rigor mortis may set in after so and so after death it stated that rigor mortis to reach leg to the head will take 12 hours. The same would remain in existence for another 12 hours, and thereafter it gradually diminishes in the reverse direction, that is from head to leg, taking another 12 hours. And on the basis of when we examine the tissue, found the alternative of reverse almost at the end of the cell. By this process, it so the prosecution began. Examine the other point, but no question was given in regard to this part of the variance. That was not suggested to the doctor by prosecution. That should have been. Okay, now it's back kari Google karo. এইটারে Google রে জীবন ছাড় বন্ধ করে দিল পুরা বন্ধ করে দিল কাটি দিল Google করা তার ই ପାଇଁ সেটাର ଏଇଟା କୋଉଠି ଅଛି ଏଥିରେ ମାରିଲେ ହବ ନାଇଁ ସେପଟକୁ ମାରିବାକୁ ଲେଖ ଟାଇମ୍ ଅଫ ଡେଥ୍ ଟିକେ ଛାଡ଼ିକିନି ରାଇଗର ମାର୍ଟିସ୍ RIGOR ହଁ ଠିକ ଅଛି ଆସିଗଲାଣି କ୍ଲିକ୍ କର ଯା ତମେ ଯା ଦେଖା ହଉଛି ଆଉ ଟିକେ ଇଆଡୁ ଘୁଞ୍ଚି ଯା।
Progresses to the limbs over the next few hours.
ଉପରୁ ସେଟା ତଳକୁ ଯିବ ହେଲା
Completing between 6 to 8 hours after death.
rigor mortis then stays for another 12 hours. That means still 24 hours after death and then starts disappears.
And that also disappearance process takes another 12 hours.
সেটা দেখছিল এটা হচ্ছে rigor mortis one of the most well known taphonomic alteration and it is the process by which the body's muscles stiffen resulting in rigidity as a result of variety of chemical changes in the muscle structure. Then back straight. Doctor let go not determinative determinative TIE factor Splendid. Here we are not this এটা ক্রস হইতে হবে লাভার বলছি ঠিক আছে আর হচ্ছে 36 ঘন্টার পরে time of death is basis of assessment is a probability the remaining evidence therefore consider independent ସେଇଟା ଆମର ଯୋଉ ଗୋଟେ ମାନେ ଆଇ ୱିଟନେସ୍ ଅଛନ୍ତି ହଁ ମାନେ cannot be the that cannot be you must clearly because the CGO doctor type with the tari basis something that basis cannot be এটা এগুলো আউটলাইন টাইপ করো সেটু টাইম অফ ডেথ তা কন্টিনিউ করো এন্টার was wanted to non-venture liquid has to conclude that there is a strong possibility that the death of the deceased person would have occurred 39 hours before the postmortem that is much prior to the time suggested by the professor. If this doubt regarding the time of death is reasonable, then the prosecution case should not stop straightway. But in view of the fact that the two courts below have thought it fit to rely on the evidence of the eyewitnesses and other circumstantial evidence,
and the doctor service only probability. Other methods should be considered independently of the method. So, correct.
ଏଠି यार पेन ଇଏଟା ଦିଅ और जो अंडरलाइन ଅଛି ବସେଇଛନ୍ତି ମାନେ
ହାଇଲାଇଟ୍ ଦିଅ ହାଇଲାଇଟ୍ କାମ କରୁନି
ଏଇଟା କାଇଁ ହଉନି କଣ ପାଇଁ ନା ନା କିଛି ନାହିଁ tomorrow. Is it CPC Urato? এটা এটার প্রিন্ট আউট করো। Take down the input and line on the line put.
Pardon me, Lord.
Yeah.
Can I take a leave for 1 minute?
Yeah.
Can I take a leave for 1 minute?
Take down JCRLA number 150 of 2005. The appellant Profullo Patro faced trial in the court of London ad hoc additional session judge Bonai in sessions trial number 24/67 of 1999-2004 for offense punishable under section 302 of the Indian Penal Code on the accusation that on 29th August 1998 at 4 p.m. at Molarbago, Bodojuro, Nola, situated near village Sarsara, under Tikayatpalli police station in the district of Sundargarh, he committed murder of his wife Subhadra Patra, bracketary here of the deceased. The London Trial Court, by judgment and order dated 23/8/2005, found the appellant guilty as the offense charged and sentenced him to undergo imprisonment for life and to pay a fine of rupees 1,000, in default to undergo SI for 6 months. The prosecution case, as per the first information report lodged by Tikeswar Patra, bracket PW2, on 29/8/1998, before the Inspector of Police, before the Circle Inspector of Police, Bonai, in short is that On that day, at about 2 p.m., he was in his house, and at that time, one person, namely Natho Patra, came and informed him that his bracket PW2 apostrophe S PW2 bracket ends son-in-law, that is the appellant, had committed murder of the deceased, who was the daughter of PW2, and that the dead body was lying at Bodojoro Nala at Malar Basu. Hearing such news from, getting such information from Natho Patra, PW2 came to the spot and found that the deceased was lying dead in the water channel at Malar Bas, and stab wound was noticed on the right side abdomen of the deceased, and number of persons had congregated at this spot. When PW2 confronted Kunti Patra, bracket PW4, Reboti Patra, bracket PW5, Minati and Minati Patra, they told that on that day at about 1:30 p.m., they were engaged in weeding operation in the land of one Srivacha Patra, and all on a sudden they heard inverted comma ভিতরে মারিদেলা ଏପଟେ ଟିକେ ବୁଲିକିନା ଆସ ଏଇଟା କାଢିକି ଦେଲ ପ୍ରିଣ୍ଟ ଆଉଟ୍ କାଢିବାକୁ ଦେଇକିନି ତାପରେ ଦେଲେ ପୁରା କହିଲେ what you are doing. Training underline ହେଲା ଆସୁନି ବୁଝୁଛ, what is the utility? सी कौन सेठू ये कोजी अरे कि आमे जोटा को अंडरलाइन कर विल डिटरमिन सी सेठू बसिन कोजी एटा काई होनी इज नो आंसर है ना कौन लिखिले and looked towards the place of shout and noticed that the appellant stabbed the deceased and the appellant had stabbed the deceased and the dead body of the deceased was lying in the water channel. And while they rushed to the spot, the appellant fled away towards jungle, holding the knife. And they also noticed stab wound in the belly of the deceased. It is further stated in the first information report that 3 years prior to the occurrence, the deceased married to the appellant and they were staying together. And the appellant used to assault the deceased and on Wednesday, that is on 26 bracket election, that is on 26/8/1998 morning, since the appellant नाली पेंसिल ने मार दी बेटा अच्छी नाली पेंसिल हाँ कौन है ना in the morning on the Wednesday लिखिले तो assaulted the deceased comma she came to her father's place and complained before the secretary of the village, Lingaraj Patra, bracket PW3. On 29/8/1998, when the deceased had been to attend call of nature to Bodajoro Nala, the appellant followed her and killed her by stabbing knife. PW2 along with PW13, Vashant Naik, came to the police station, orally reported the incident to police. Who is the investigating officer?
P2 14 madam. Kalucharan Patti.
PW14 Kalucharanapati, the Circle Inspector of Police Bonai, reduced the oral version of PW2 into writing, read over and explained the contents thereof to him, who admitted the same to be correctly recorded, and accordingly his signature was taken and it was treated as first information report. And PW14 registered Tikayatpalli PS case number 15 dated 29/8/1998 under section 302 of the Indian Penal Code against the appellant. And he himself took off investigation of the case, Sapara. During course of investigation, PW14 examined the informant (PW2) and the accompanying witnesses, recorded their statements, visited the spot, and prepared the spot map Exhibit 11. He also held the inquest over the dead body in presence of the witnesses and prepared the inquest report Exhibit 3. Stop. He seized the sample earth and bloodstained earth from the spot in presence of the witnesses and then sent the dead body for post-mortem examination to SD Hospital, Bonai, through constable. On 29/8/1998, PW14 seized a letter written by the deceased, which was kept in the custody of PW3 Lingaraj Patro on his production as per seizure list Exhibit 4. Stop. On 30/8/1998, PW14 seized the wearing apparels of the deceased on production by the constable after the post-mortem examination, which were seized as per seizure list Exhibit 10. The appellant was arrested on 5/9/1998, and while he was in custody. He confessed his guilt, and on the basis of his statement, which was recorded under Section 27 of the Evidence Act, in presence of witnesses, and on being laid by the appellant inside Jagyon Hudi wheel, the weapon of offense, that is knife bracket MO1, which was concealed near a rock, was seized as per seizure list Exhibit 6. The appellant also stated to have kept the wearing apparels which he had worn at the time of occurrence and took the police party to his house and produced the wearing apparels, that is one ganji, check lungi, and one napkin, which were seized in presence of the witnesses as per seizure list Exhibit 7. Requisition was sent by the IO bracket PW14 to the medical officer Sarsara for collection of sample blood and nail clippings of the appellant, and on the same day it was produced before him and seized as per seizure list Exhibit 1. And on 5/9/1998, the appellant was forwarded to court. After receiving the postmortem examination report, PW14 made a query from the SDMO Bonai by sending the weapon of offense, that is knife, for seeking an opinion regarding possibility of the injury sustained by the deceased with such weapon. He also made a prayer before the learned SDGM Bonai to send the seized articles for chemical examination to RFSL Ointapali, Sambalpur, and receive the CE report Exhibit 16. On 19/10/1998, PW14 examined some more witnesses and recorded their statements, and on 1/2/1998, on completion of investigation, he submitted charge sheet against the appellant under Section 302 of the Indian Penal Code. The case was committed to the Court of Session after complying due procedure, where the London Trial Court framed charge as aforesaid, and since the appellant pleaded not guilty and claimed to be tried, the Sessions trial procedure was resorted to establish his guilt. In order to prove its case, the prosecution examined 14 witnesses. The prosecution also exhibited 16 documents. Prosecution also proved 6 material objects. The London Trial Court, after assessing the oral as well as documentary evidence on record. Came to hold that from the inquest report Exhibit 3 and the post-mortem report, bracket Exhibit 8, and the evidence of the doctor, bracket PW8, who conducted post-mortem examination, it was evident that the deceased suffered homicidal death. The London trial court assessed the evidence of two eyewitnesses to the occurrence, that is PW4 and PW5. And found that nothing was elicited to discredit the testimonies of these two witnesses. And that there is no such contradictions in the evidence of these two eyewitnesses. The London trial court further held that though one Minoti Patra was in the company of PWs 4 and 5 while the weeding operation was going on, and she has not been examined during trial, but the same cannot be a ground to disbelieve the prosecution case. The evidence of PW 4 and 5 was held to be reliable and trustworthy, and leading to discovery of the weapon of offense, that is knife bracketry MO1, on the basis of the statement made by the appellant, was also held to be corroborative to the direct evidence of PW 4 and 5, coupled with the evidence of the doctor bracketry PW 8. The London trial court further held that there was motive behind the the London Trial Court further held that even if the motive of the accused is not established, since there is overwhelming evidence on record that the appellant caused the fatal injury on the deceased resulting in death, it is sufficient to convict the appellant. Accordingly, the London Trial Court concluded that basing on the testimony of the informant and the eyewitnesses to the occurrence, that is PW 4 and 5, which gets ample corroboration with the evidence of the medical officer, the prosecution has been able to prove its case beyond all reasonable doubt against the appellant that it is none else than the appellant who committed the murder of the deceased. Accordingly, found the appellant guilty under Section 302 of the Indian Penal Code. The learning counsel for the appellant, Mr. Sambit Mahanti, learned counsel, appearing for the learning amicus curiae, contended, appearing for the appellant, contended that the presence of the two eyewitnesses, that is PW4 and PW5, at the scene of occurrence is very much doubtful. He submitted that the place where the two witnesses were weeding out the grass from the cultivable land of one Srivatsha Patra and heard the noise, in view of the distance of the spot from the place of weeding, they could not have marked the appellant leaving this spot in view of the distance factor as has been brought out from the evidence of the IO. It is further argued that according to the evidence of these two eyewitnesses, the occurrence took place at about 1 to 2 p.m. on 29/8/1998. And the doctor who conducted post-mortem examination on the very next day, that is on 30/8/1998, stated that time since death was more than 36 hours as rigor mortis had passed off. 36 hours of his post-mortem examination as the rigor mortis has passed off. Since the post-mortem was conducted at 11:30 a.m. on 30/8/1998, it was within 22 hours of the time as stated by the two eyewitnesses. And therefore, in view of the post-mortem report finding, the death could have occurred much prior to the date and timing stated by the eyewitnesses, and therefore their version that the occurrence took place in between 1 to 2 p.m. on 29/8/1998 is not acceptable. The Lennon Council further argued that though the knife was seized at the instance of the appellant, but the C report indicates that no blood was noticed on it, and therefore the recovery of the knife is inconsequential. The Lennon Council further submits that in view of the absence of motive behind the clinching evidence regarding the motive behind commission of the offense, when the evidence of the eyewitnesses are a doubtful feature, particularly taking into account the time of death as stated by the post-mortem examination Dr. PW8. It is a fit case where benefit of doubt should be extended in favor of the appellant. Mr. Arupananda Das, an additional government advocate, on the other hand, submitted that rigor mortis cannot be the determinative factor for ascertaining the exact time when the assault took place on the deceased, and it depends upon variety of factors as per the medical jurisprudence. And since the only reason assigned by the Dr. PW8 that time since death was more than 36 hours, as rigor mortis had passed off, is against the medical jurisprudence. On the basis of such experts' evidence, the evidence of the two eyewitnesses, that is PW4 and PW5, cannot be discarded, particularly when nothing has been brought out in the cross-examination to disbelieve their evidence. The Lennon Council further argued that the witnesses were at a distance of about 100 feet from the spot, and the land in which they were working was at a higher level than the nala where the dead body was found, and it was an open field. There would be, and therefore there would be no visibility of any hindrance to their visibility factor, and their statement that they saw the appellant running away from the spot holding a knife cannot be discarded on that ground. The Learned Counsel further drew the attention of this court to the evidence of the witnesses which indicate that the deceased had complained against the conduct of the appellant in assaulting her few days on ସେଇ ଦିନ ନା କୋଉ ଦିନ ସେ ମାରିଥିଲା ତାକୁ ସେ ଯୋଉ ରିଟିନ୍ କମ୍ପ୍ଲେଣ୍ଟ ରେ
ବୁଧବାର ହେଇଥିଲା ଏଟା ଶନିବାର ହେଲା।
ହଁ ନାଇଁ ଘଟଣାଟା ହେଲା ଶନିବାର ଦିନ
ଆଜ୍ଞା।
ହଁ few days prior to the date of occurrence and therefore and a complaint was lodged before the headman of the village and a meeting was supposed to be held on Monday, but the occurrence in question took place on Saturday, and therefore, in view of the eyewitnesses account coupled with the medical evidence and the previous background, it can be said that the appellant, that the prosecution has successfully established its case against the appellant and there is no infirmity in the impugned judgment. Adverting to the contention raised by the Learned Counsel for the respective parties, let us first see whether the prosecution has successfully established that the deceased met with homicidal death or not. Apart from the inquest report, bracketary Exhibit 3, prepared by PW14, the IO, the Dr. PW8 who conducted the postmortem examination at Subdivisional Hospital, Bonai on 30/8/1998 at 11:30 a.m. noticed the following injuries, scored the injuries. Then he noticed the following internal injuries. And on internal examination, he found as follows, quote कर दूं. PW8 opined the cause of death to be hemorrhage and shock resulting from stab wound, and the time since death was more than 36 hours as rigor mortis had passed off his PM examination. He has proved his report, exhibit postmortem report, marked as Exhibit 8. On 10/9/1998, on police requisition and query made by the IO bracket PW14, he examined the weapon of offense, that is knife, and opined that the injury sustained by the deceased could be caused by the knife produced before him, and the injury number 1, that is the stab wound, could cause the death of a person in ordinary course of nature. PW4 and PW5, therefore, in view of the inquest report, as well as the evidence of the doctor PW8 and the postmortem report, we are of the view that postmortem report is Exhibit 8. We are of the view that the Learned Trial Court has rightly come to the conclusion that the deceased met with a homicidal death. So far as the opinion given by the doctor that time since death is more than 36 hours as rigor mortis had passed of his PM examination will be dealt later on while assessing the evidence of the two eyewitnesses to the occurrence. Next para. PW4 Srimati Kunti Patra has stated that at the time of occurrence, it was 1 to 2 p.m. and she along with PW5 and one Minati Patra were weeding out the grass from the cultivable land of Srivatsya Patra. And the Malarbasa Nala was at a distance of 100 feet from the place where they were working. And hearing the cry of the deceased Marigali Bua, they rushed to the spot and found the deceased was lying dead at the spot with profuse bleeding injury on the right side belly. And they also found that the appellant was running away from the spot holding a knife towards jungle. They raised alarm for which the villagers came to the spot. In the cross-examination, PW4 has stated that their land was at a higher level than Nala and the Nala was visible to their Kiari. And they were to go to Nala through the land of one Sodapatra. She further stated that they three simultaneously came running to the spot. She further stated that nobody was at the spot by the time of their arrival and it was a rainy season. However, at the relevant time, it was not raining. She stated that she had not seen the assault on the deceased by the appellant. Though some previous statements were confronted to PW4 that she had not stated about hearing the cry of the deceased and that they raised alarm and thereafter the villagers came to the spot and that the appellant was running away from the spot holding the knife. And it was proved through the IO bracket PW 14. However, we find that the statement recorded under section 161 CRPC clearly mention all those aspects. When the 161 statement was confronted to the witness, it was nonetheless the duty of the public prosecutor, so also the London trial court, to verify such statement whether the confrontation was correctly made or not. And when the investigating officer comes and the confrontations are proved, at that time also both the public prosecutor and the court should be careful. In this case, had the public prosecutor and the court would have been vigilant, the London Defense Council would not have been permitted to make such confrontation regarding absence of statements in the 161 recorded under section 161 CRPC. We find that nothing has been brought out in the cross-examination to disbelieve the evidence of PW4. It has been brought out from the evidence of the IO that there is no passage to the stream from the land of Srivacha Patra, and one has to come to the Nala through the field. From this evidence, we are not in a position to accept the contention of the learned amicus curiae that by the time PW4 and PW5 reached at the spot, the appellant would not have been there. And stop. When the appellant, when both the eyewitnesses were at a distance of just 100 feet and hearing the shout of the deceased, they rushed to the spot. It cannot be said that they would not be in a position to mark the appellant running away from the spot holding a knife. The evidence of PW5 corroborates the evidence of PW4. She has also stated that she, along with PW4 and Minati Patra, were weeding grass from the land of Srivacha Patra, and hearing the cry of the deceased, they rushed to the spot and found the deceased was lying dead with bleeding injury on her belly, and at that time the appellant was running away towards the jungle holding a knife, and they noticed profuse bleeding injury on the belly of the appellant, and they raised holla and the villagers came to the spot. She has also stated in the cross-examination that she had not seen the assault on the deceased, and further stated that the place where the dead body was lying was not visible to the place where they were working. However, the position of the field is such that if someone comes to one end of the field after hearing the noise, she can easily see the place where the deceased was lying in view of the distance factor of just 100 feet. So also the fact that the land was on the it was situated at an upper level. Nothing further has been elicited in the cross-examination to disbelieve the evidence of PW5, merely because the other witness, namely Minati Patra, was not examined by the prosecution, the same cannot be a ground to disbelieve the evidence of these two eyewitnesses. Now, coming to the timing of occurrence, as stated by both these eyewitnesses, it was on 29/8/1998 in between 1 to 2 p.m. if the time when the doctor bracket PW8 conducted postmortem examination is taken into account, that is 30/8/1998 at 11:30, then it can be said that the postmortem was conducted within 22 hours of the death of the deceased. No doubt, the doctor has stated that the time since death was more than 36 hours as rigor mortis have passed off. 36 hours of his PM examination as rigor mortis have passed off. But ଏଗୁଡାକ ମାର୍କ କରିଦେବେ ଯୋଉଟା ଲେଖା ହେଇଛି ସାର୍ ଅଣ୍ଡରଲାଇନ୍ କରିଛନ୍ତି ଲେଖିବେ in view of this one. Therefore, rigor mortis depends upon several factors, and no straitjacket formula can be laid down as to that in every case that would appear at a particular point of time and disappear after a particular time, irrespective of the weather, the age, the surroundings, the type of assault made to the deceased, etc. The learned counsel for the appellant placed reliance in the case of so and so, note then you cite decisions that are relevant. Birendra versus State of UP, reported in 2008, 16 SCC 582. Another decision is 2002, 6 SCC 498. So these decision the relevant paragraph. In the case in hand, since the reason assigned by the doctor is not in consonance with medical jurisprudence, and when the evidence of two eyewitnesses are clear, trustworthy, and reliable on the basis of the expert's opinion, we cannot disbelieve the expert's opinion with respect to the time since death. We cannot disbelieve the evidence of the two eyewitnesses, particularly when he has stated that with the weapon of offense sent to him, the injuries noticed on the deceased were possible. The weapon of offense was seized after a few days, and it was a rainy season as stated by the witnesses. Therefore, non-finding of the blood on the knife as per the C report, Exhibit 16, cannot be a factor to also doubt the prosecution version that knife was used in assaulting the deceased. From the evidence of PW3, I would say जो witness टा किए से जो complain कथा कुछ जो नौ ना कहते हैं
PW3.
हाँ
PW3 and PW9.
9. PW3 and PW9, it appears that a written complaint was made by the deceased relating to her assault by the appellant, and PW9 handed over the written complaint to PW3 with instruction to settle the matter, and the meeting was supposed to held on Monday, but unfortunately the occurrence took place on Saturday, that is 29/8/1990. आगे लिख देबो तापर लोग Saturday. Therefore, the prosecution has also established the motive behind the commission of the crime. In view of the foregoing discussions, when the eyewitnesses' account are acceptable, which is getting corroboration from the medical evidence, and the motive factor is also present in the case, we are of the view that the Lennon trial court has rightly held the appellant guilty under section 302 of the Indian Penal Code. In view of the foregoing discussion, we find no merit in this JCRLA, which is accordingly dismissed. He was on bail or? Huh? It appears that the appellant was granted bail by this court as per the order dated
4/5/2010.
4/5/2010, shall surrender before the London Trial Court within 2 weeks from today, failing which the London Trial Court shall take steps for his arrest to serve out the sentence. Put a note of appreciation on Mr. Sambit Mahanti, so also Mr. Das, and 7,500 is to be given to Mr. Mahanti. এটা জীবো না মার্চেন্ট
May please your lordships. One interim bail, one criminal appeal. Bail, your lordships, the sister of the appellant is getting married. I file a petition for interim bail and a criminal appeal for hearing vigilance matter, your lordship. He is going to retire this year.
Lordship, two criminal appeals, Lordship. One appeal, appellant has already undergone 7 years out of 10 years custody, and another in another matter, 10 years custody is already undergone by the appellant out of the 20.
Give it.
Or juvenile bail, my lord. Another my lord, tired matter, your lordship, tired matter bail, my lord.
This is also my lord juvenile, my lord.
Lordship, tired of matter.
I for bail.
My lord, a criminal appeal for SC/ST Act, my lord. 1366 of 2023 से 31/1/24 रे थिला से आजि पई थिला 12/2/24 जगह रे 23 हे येची ऑर्डर शीट रे सेति पे सेटा आसी पान
Lordship, interim bail, Lordship, for marriage of his sister, Lordship. And another is for verification documents, Lordship, petitioner belong to West Bengal.
Oh, yes. All right. Since the progress of the trial is at a snail's pace, I am of the humble view that the petitioner is entitled to be released on bail, subject to conditions that he shall furnish bail bond of rupees 5 lakhs with two local solvent sureties. Further conditions shall not directly or indirectly make any inducement, threat, or promise to any witness so as to dissuade him to disclose the fact of the case within his knowledge to the London Trial Court. He shall remain present before the London Trial Court on the date fixed for hearing of the case. He shall surrender his passport, if any, if not already surrendered before the London Trial Court. And in case he is not the holder of the same, he shall swear an affidavit to that effect. If he has already surrendered before any court or investigating agency, the said fact should also be supported by an affidavit. He shall furnish his place of abode where he will be residing after his release on bail, and also disclose his phone numbers, WhatsApp number, and email address to the Inspector of Police, CBI, ACB Bhubaneswar. Liberty is granted to the CBI to make an appropriate application for modification / recalling the order passed today if for any reason the petitioner violates any of the conditions imposed by this court. The bail appeal is accordingly allowed.
Quickly list item number 1.
Yes, time extended.
Item number 2.
Time extended.
Item number 3.
Time extended.
Item number 4.
Time extended.
Item number 5.
Time extended.
Item number 6.
Time extended.
Item number 7.
All right, time extended. Next. Yes. Next.
Item number 8.
Time extended.
Item number 9.
9, my lord. In this case, the petitioners are in custody since, my lord, 10/4/2015, and standing on the similar footing, my lord, other co-accused persons have been released on bail by your lordship. My lord, the record also has come.
You are in custody since which date?
My lord, since 10/4/2015.
You are never released on bail during trial or earlier by this court?
No, my lord. Since then, we are in custody. And your lordship has granted bail that your lordship has mentioned more than 8 years there in custody. I am also for more than 8 years.
Yes, Mr. Are the learned counsel for the petitioner, learned counsel for the state देखिए. Considering the submission made by the learned counsel for the petitioner that the petitioners are in judicial custody for more than 8 years out of 10 years of substantive sentence imposed on them by the learned trial court. बाकी सब जहाँ देखी नहीं लिखी हुए, and there is no chance of early hearing of the appeal in the near future, and paper book has not been prepared. Later and that some of the co-accused persons who are the appellants in the connected CRLA number 131 of 2018 have been granted bail by the order dated 12/12/2023, copy of which is filed and taken on record. I would achieve the data. That is appellant Narayan Barik in CRLA number 225 of 2018, order dated 9/1/2024. I am inclined to release the appellant on bail, same terms and condition. Appellants करिए. एटा कहाँ पे फाइल कर जंदी?
My lord, for four appellants, my lord, Durjo Naik, Lingaraj Maji, Shankar Naik.
All the appellants.
My lord.
All right. And they belong to our Kalahandi. अच्छा, all right. एटा ये seal मारी की नहीं दियो? Seal मारी की नहीं बड़ा होता है? कौन से document file है? Yes, and also stay realization of fine. Yes.
Number 10.
Please, Lordship, my lord, for address verification of appellant as well as appellant number 1 as well as the surety of Bhimana Gowdu called for by this honorable court.
You are moving for bail of one Nandaram.
Yes, madam.
And the last order, which is dated 22/1/2024,
Yes, madam.
You submitted, Mr. Das, that address verification has been made and surety verification is awaited.
So far, there are two appellants. One is Rajiv Kumar sir, and another is the Nanda madam.
No, this bail application which has come today, that is only for Nandan Ram.
Address verification sent for both of the appellants. The Rajiv Kumar was found correct. But so far the Nanda is concerned matter that is still awaiting. We have not received from the.
But you made a submission on 22/1/2024 and Mr. Tripathi was there. Not you, but Rajesh Tripathi. He said that address verification has already been made and
Address verification made. But so far the second one is concerned because Nanda is concerned not be received. Let it be Monday.
And what about the surety?
Surety they have given my lord. That has also sent it. We have already sent it. I think Monday I will get it.
Learned counsel for the state IA number 579 of 2023. Learned counsel for the state seek some further time to obtain instruction about the address verification of petitioner number 1. Appellant number 1 कर दें. Appellant number 1 Nandaram alias Karan, who is the sole petitioner in this interim application. So also the surety verification. Sureties verification.
Surety is only valid for one surety.
One surety. अच्छा
Yes, sir.
surety verification कर दूं. गोटेटा ठीक बासिला. Okay, surety verification. Put up this matter on the week commencing from 19th of February 2024. Yes.
Item 11.
My lord, petitioner has been surrendered.
to the certificate. The offense substantial sentence 10 years.
Just
The
a minute.
petitioner before your lordship is a driver.
He has been granted interim bail of traveling.
Yes, sir.
6 some time to produce. Yes, custody certificate kete hala?
Yes, Miller. At on 19/11/23, he was 4 years 6 days.
19/11/2023 हाँ केते 4 years
6 days.
आउ ହେଇକିନା ଆଉ ଇଏ ତ ଆଉ 2 ମାସ ହେଇଛି ଆଉ କଣ 2 ମାସ ହେଲେ 2 months ଆପଣଙ୍କର half of the sentence ହଉନି
Petitioner before your lordship is driver. Your lordship. In 20B, the second driver. Therefore, your lordship call for the
yes
and granted interim bail.
stay for half of the sentence then will it will adjourn kar diyon learning counsel for the state has produced the custody certificate has placed the custody certificate from which it reveals that as on 19/11/2023 23/11
Yes.
as on 23/11/2023 the petitioner has undergone 4 years 6 days of sentence
4 years 6 days
of sentence and counsel for the appellant 6 for an adjournment put up this matter adjourn kar diyo yes
Item 16.
May it please, my lords. My lords, on behalf of Mr. Das, I may be permitted.
The report has come.
Yes, sir.
Here you the status report submitted by the London Trial Court dated 9/1/2024, from which it reveals that after availing the interim bail period, the petitioner didn't surrender, for which non-bailable warrant of arrest has been issued against him. And also steps have been taken to forfeit the bail bonds. The London Trial Court shall report as and when the appellant is taken into judicial custody. Copy of the order be communicated to the London Trial Court. Yes.
Blessed.
Item 19.
will under State Council to obtain instruction regarding any appeal is referred or not.
What appeal?
My lords, that is order dated 4/1/2024.
And council seeks some time to obtain instruction on this. Also, they obtain instruction as to whether the state government is. Okay, it's an order of acquittal.
My lords.
Whether there is any proposal to prefer any appeal.
No, my lord, there is no appeal and also that has not been filed.
All right, the Land and Council for the state on instruction submitted that neither any appeal has been filed by the state nor there is any proposal to prefer any appeal against the impugned judgment and order of acquittal. Now, who is this Shirkant Digal?
My lords, he is the son of the owner of the vehicle, my lords. His father has died, my lords, in the meanwhile. I have annexed it at Annexure 2 series, my lords.
No, this appeal is
for release of the vehicle, my lords.
Release of the vehicle.
My lords.
He was not an accused.
My lords, he was one of the accused, my lords.
Okay. What stand has been taken by you?
My lords, as he was inside the custody, my lords. So, and without issuing any notice and opportunity of hearing. That
No, what is your stand about the vehicle? Because in the vehicle, you are found in it.
Yes.
The prosecution case is that,
my lords,
on that 3/2/2022, some reliable information was received about the transportation of ganja. Then they went to that place and one white color Bolero maxi truck whose number has been given and another Bolero number has been given.
My lords.
They were, it was found that that was coming and drivers of both the vehicles, when the police officials tried to stop the vehicle, driver of both the vehicles tried to escape, but they were detained. Then driver of the vehicle registration number so and so disclosed his name as Golok Digal.
My lords.
And driver of registration number so and so disclosed his name as Srikant Digal.
My lords, the president.
You are that person.
Yes, my lords.
Hey, hata dekhi. Mera man. কোন এটা উপরটা কোন এটা কোন এমতি ଏମିତି କଣ ଆସୁଛି So what is your stand so far as the vehicle is concerned? Because you are on that in that vehicle and you tried to escape, you are caught hold of, and that vehicle number has been given, that vehicle was seized.
My lords, here the present appellant, he is not present at the vehicle that has been challenged here, my lords. He is present on another vehicle, my lords. That is, I have filed for OD05E1904. My lords, the present appellant is present in the vehicle that is Bolero Maxi Truck registration number OD33K7833, my lords.
You are seeking release of which vehicle?
My lords, OD05E1904.
That is another vehicle which
lords.
was also seized in connection
My lords,
with that case.
My lords, my humble submission before your lordship is that the present appellants are acquitted in this matter and they have not.
Acquittal is something different. Acquittal in NDPS Act may be for variety of reasons. Somebody, suppose non-compliance of the mandatory provision, he will be acquitted. That cannot be a ground ipso facto to release the vehicle in your favor. So even if an order of acquittal is passed, the vehicle cannot be released in favor of the accused.
My lords, but my lords, here no notices are issued to me and no chance is given, my lords, and it has been confiscated. My humble submission is that I have not given a chance of hearing, my lords.
What is your stand so far as the other vehicle is concerned, which you are claiming to be your vehicle? During trial, did you claim that this vehicle is yours?
No, my lords, I was in custody at that time, my lords. So I could not adduce any evidence regarding that. And after the death of my father,
ଆପଣ ଷ୍ଟାଣ୍ଡ ବି ନେଇନାହାନ୍ତି ଯେ ସେ ଭେହିକିଲ ଆପଣଙ୍କର ଡକୁମେଣ୍ଟ ତ ପ୍ରଡ୍ୟୁସ କରିବା ଦୂରର କଥା କୌଣସି ଷ୍ଟାଣ୍ଡ ନେଲେନି ତ ବର୍ତ୍ତମାନ ଆପଣ let us come to the operative part of the order.
My lords, that is at running page 25, my lords.
देखिए एनडीपीएस एक्ट है yes, which are the provision you say?
My lords, I am relying on judgment.
Don't rely on reason. First, place the evidence provisions, and so that once you are acquitted, you will get back the vehicle.
My lords,
and what is the procedure laid down for confiscation?
My lords, that is section 63, my lords.
63.
My lords, procedure in making confiscation.
No, first of all, section 60 says,
my lords,
that confiscation can be made.
My lords.
Section 60, subsection 3.
My lords.
Any animal conveyance, here is a conveyance,
my lords,
used in carrying any narcotic drug or psychotropic substance,
my lords,
so and so, or any article liable to confiscation under subsection 1 and 2 shall be liable to confiscation unless the owner of the animal or the conveyance proves that it was so used without the knowledge or connivance of the owner. You are the owner here.
My lords.
And you are using that vehicle.
My lords.
If any, that person in charge so and so, and that each of them had taken any reasonable precaution against such use. So suppose somebody is not an accused, his vehicle has been used in the crime, and he proves to the satisfaction of the court that I am not aware. The gentleman who was using my vehicle in commission of the crime, he had it was without my knowledge, and the court is satisfied with such ground. Then, and apart from that, he had also taken all reasonable precautions. So not only he has asked his driver not to use the vehicle in transporting the contraband article, but also taken all sorts of precaution. And if he places that case in that way and the court is satisfied, then the way that will not be confiscated. So that language of subsection 3 of section 60 makes it very clear. Otherwise, you are liable, that vehicle is liable to be. Here is a case where you are not only the owner, but you are present and along with the contraband ganja. So how this aspect would be satisfied?
My lords, but I was not present in that vehicle, my lords.
You may not
My
be
lords.
present.
My lords.
Going in one vehicle, you are present, in the other vehicle, another co-accused. Merely
My
because you exchange the vehicle, that doesn't mean that it will be. So the vehicle which was used
My lords.
in transporting the ganja, it was very much within your knowledge because the two vehicles were carrying ganja. And 63 itself says that whether he is convicted or acquitted, discharged, whatever it may be, this confiscation is a separate proceeding.
My lords.
The court shall decide whether any article or thing seized under this act is liable to confiscation under section 60, 61 or 62. And subsection 2 of section 63, it says that where it is not known who committed the crime, that is a different matter, but here it is not a case. Provided that no order of confiscation of any article or thing shall be made unless expiry of 1 month from the date of the seizure, or without hearing any person who may claim any right thereto, and the evidence, if any, he produces in respect of the claim.
Lords, may I pray for next week I will satisfy, my lords.
So, Mr. Mahapatra,
My lord.
just we are adjourning the matter because he is making a.
My lord.
You just verify. 63 makes it clear
Well.
that whether he is convicted, acquitted, or discharged, confiscation can be done.
Well.
And one person can, if satisfies the court as per section 63,
Well.
that his vehicle was used without his knowledge or connivance, and he had taken all kind of precautions, then only it would not be confiscated, and it would be released in favor of the owner. Otherwise, there is no other provision. But one thing, as it appears from the proviso to subsection 2 of section 63, that the opportunity of hearing is to be provided to the person who is claiming any right, and he has to also be given to adduce any evidence that is there. Here, the moment you pronounce the judgment of acquittal, in the very same order, you pass the order. Whether that is permissible or after acquitting, so far as the confiscation is concerned, you should have dealt with separately, issuing notice to the person and giving an opportunity of hearing and then passing the order.
And in this case, whether my lord during course of trial he was provided with that opportunity to show that my lord
No, that might not have been there because he is not taking any stand
there
during, because
nothing in
he
the
is now,
judgment.
he was fast, his aim was to get an order of acquittal.
Yes, that
Right.
has not been.
So at that point of time, he sees that if I take all this, that it is my vehicle, I was taking it with so and so.
That will be
So
automatically
that would be a dangerous thing. So that is why he, so far as the vehicle is concerned, he is not. Now he has got the acquittal order. So question now remains that in the very same order, when the order of acquittal has been passed, and
the confiscation order was has been given, can be given or not, or separate proceeding,
because vehicle's involvement is proved.
Yes.
So as I said, that they might not have been. What is the reason of acquittal? That is also another.
Yes.
It is not that if it's a case that this vehicle was not at all used for the commission of offense, that's a different matter. But if the vehicle has been used, but for some other reason, like non-compliance of mandatory provision
that has been there,
or anything, the accused has been acquitted. So question now remains for consideration whether in such a case a separate proceeding for confiscation is to be initiated, because the proviso to subsection 2 to section 63 states about opportunity of hearing and adducing evidence. So that has not taken place. So if that has not taken place, the order is passed, the order can be set aside and a proceeding can be initiated in accordance with law, opportunities to be given, and then the appropriate order can be passed. So it is not that at this juncture, the moment I said that it will be released in his favor. That is not the thing. So that aspect both of you also examined, right?
My lord.
By the way, just I want to know that what is the ground for which the order of acquittal was passed? Non-compliance of mandatory provision. And about the proper custody of brass seal. So these are the various factors which were taken into account. Whether it was kept in Malkhana in safe custody. So 55 provision, 57, all these things were taken into account and he has been acquitted. All right. সেটা जो ডাকিଥିଲି লিখছিল না যে নো অপিল তারপরে লেখুন সব পারাগ্রাফ লেখুন the learned counsel for the appellant drew the attention of this court to subsection 3 of section 60 and first proviso to subsection 2 of section 63 of the NDPS Act, and contended that since no opportunity of hearing has been provided to the appellant while passing an order of confiscation of his vehicle, bearing registration number OD05 as a Bolero vehicle कर दियंतु, bearing registration number OD05E1904. The order of confiscation is illegal and not sustainable in the eye of law. Learned counsel for the state submitted that the order of acquittal was passed on the ground of non-compliance of some mandatory provisions. And during trial, the appellant has not claimed the ownership of the offending vehicle. However, he seeks time to examine as to whether, after the order of acquittal was passed for confiscation of the offending vehicles, a separate proceeding should have been initiated by the London trial court or not. Put up this matter in the week commencing from 26th February 2024.
Obligement.
Item number 30.
Melons, on behalf of Mr. Das, kindly this matter be taken off next week, Melons.
Here, the incident took place, my lords, in 2014, that is 16/12/2014. Page 14 of the brief, if your lordship will see, the custody period has been stated in the judgment.
Anant Meher.
Aye. My calculation is that he is in custody 5 years and 5 days as UTP, and as on today as convict 5 months and 15 days.
5 years କେତେ ହେଲା ସେଇଟା?
5 years and 5 days as UTP, and 5 months and 15 days as on today.
5 months ତାମାନେ 5 ବର୍ଷ 5 ମାସ।
ଆଜ୍ଞା 5 ବର୍ଷ 5 ମାସ 20 ଦିନ।
But he has given the jail superintendent Malo given the calculation of 4 months 4 years 9 months 4 days.
କେବେ କାର ସେଇଟା?
This is of 2 days Malo. 2 days instruction.
ଆଜି?
ଆଜି। As on date.
ସିଏ ସେଠୁ ହିସାବ କରୁଛନ୍ତି କେମିତି ଏମିତି ଭ୍ୟାରି କରୁଛି?
I short for he has given a
ଗୋଟେ କାମ କରନ୍ତୁ ଆପଣ ଗୋଟେ କପି ଟେ ମିଷ୍ଟର ପଣ୍ଡାଙ୍କୁ ଦିଅନ୍ତୁ ଆର ସପ୍ତାହରେ ଆଣୁଛି ଭେରିଫାଇ ଟିକେ କରିଦିଅନ୍ତୁ ଆଉ ଏଇ ପିରିୟଡ ଟାକୁ ବି ଟିକେ ଦେଖି ଦିଅନ୍ତୁ ଯୋଉଟା ଯୋଉ ସେ ଲାଷ୍ଟ କଲମ ରେ ଯୋଉ ନାହିଁ ଏତେ ଭ୍ୟାରି
16 12 14 ଟୁ 12 4 16
ଏଗୁଡା ସବୁ ହିସାବ କରିଦିଅନ୍ତୁ
5 16 ଟୁ 4 5
ସେଗୁଡାକ
ଏଇଟା ହିସାବ କରିକି ମୁଁ ବାହାର କରିଥିଲି 5 ବର୍ଷ
ସିଏ କେମିତି ହିସାବ କରିଛନ୍ତି କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ଟା ଦେଖି
ଦେଇଥିଲେ in total
ନାଇଁ ଠିକ ଅଛି ଆପଣ ଗୋଟେ କପି ଦିଅନ୍ତୁ ତାଙ୍କୁ ହେଲା learning counsel for the
he has given a detailed description subsequently I asked for you give the detailed description of the custodial period he has given subsequently that clarifying the periods I will supply to my
period ଟା tally କରୁଛି କି ନାହିଁ ସେଟା ଟିକେ
yes my lord I will supply
କାରଣ ଏଠି ପୁରା ଡିଟେଲ ମେନସନ ହେଇଛି ଯୋଉ ବାକି ଯୋଉ ଗ୍ୟାପ ଗୁଡା ରହିଛି ସେଗୁଡା ବୋଧେ ଇଣ୍ଟ୍ରିମ୍ ବେଲେ ଯାଇଥିଲା
he has given a details of
ସେଗୁଡା
calculation
ଟିକେ
I will
ଦେଖିବେ
provide to my senior
the Mr. Devasis Pandal and counsel for the appellant submitted that as per his calculation which should be evident from the impugned judgment page number 2 that the petitioner has was UTP for 5 years and 5 days and after conviction he has remained in custody
as on today
for 5 months
and 15 days
5 months and 15 days. However, the learned counsel for the state submitted that he has received the instruction from concerned jail superintendent which is dated 12/2/2024 which indicate that the petitioner is in judicial custody for 4 years
9 months
4 years 9 months and 4 days. Since there is discrepancy relating to the custody period of the petitioner, let a copy of the custody certificate obtained by the learned counsel for the state be furnished to Mr. Panda during course of the day and the matter be placed next week, that is on 19th of February 2021. Yes.
Item number 33.
May I please, Your Lordship? Lordship, this is a appeal against conviction. The operator
a victim of online fraud minor, and she has challenged the order of dated 12/9/2023 passed by the Law and Court, designated code OPID minor.
OPID Act case. You are the informant.
Yes, ma'am.
Huh?
Yes, ma'am.
So which order you are challenging?
The order of the dated 12/9/2023 at Annexure 2, ma'am.
It's all right. What order has been passed by the Learn and Trial Court on 12/9?
Yes.
For release of 457 PRPC has been rejected.
Okay. All right, Mr. Patro. Let that delay be condoned. We'll hear the matter on merit. 25 days delay. IA number so and so. There is an application for condonation of delay. The stamp reporter has pointed out delay of 25 days in preferring the CRLA. After hearing Mr. Patrol and Special Counsel for the State of Orissa in OPID Act matter and the Land Counsel for the petitioner, I am inclined to condone the delay. Accordingly, delay is condoned. Land Counsel for the Mr. Patra shall obtain instruction in the matter, put up this matter in the week commencing from 26th February 2024.
My lord, the accused has been arrested. This is the press note. Accused has been arrested from Himachal Pradesh.
Which accused?
The accused, the main accused in this.
It's all right. 26/2/2024. The Land Counsel for the appellant files a document to show that the main accused, what is his name? The Nagono.
Ratna Tripathi.
Oh, Ratna Tripathi, ଆପଣଙ୍କ ନା petitioner na, you main accused the arrest.
Rajat Kumar.
Rajat Kumar has been arrested, and the document is taken on record. Copy of which is also furnished to the Land Counsel, Mr. Patra, Land Special Counsel. Yes.
Similar matter.
Similar matter. Now there will be delay same. Take it next 41. 20 days. All right. Delay condone same. This 26 তারিখ দিন আসছে। ଆଉ ଯୋଉଟା ରହିଲା କାଲିକି ଆଡ୍ କରିଦେବା।